Hey, Dana, can you hear us? Deanna, can you hear us?
I can hear you. You hear
Let's go
me?
back to using that one.
Yeah.
Can V Martinez, can you give me your first name?
Vicky,
Is it V-I-C-K-I-Y?
Y, V-I-C-K-Y.
Okay, thank you. And then somebody else can come on, but they don't have sound.
William Lenore, just William, W-I-L-L-I-A-M, Lenore, L-N-O-I-R.
Okay, thank you. Although it doesn't look like we have any sound or video, so I'm not sure.
He doesn't have any video. He's just probably gonna have sound.
Okay, yeah, I didn't have it yet. How many people are coming on here?
And you'll be able to put this in.
Oh my goodness. Well, Judge, there's a million people on here. I don't know how I'm gonna know who's who.
I was just about to say this is a lot more than I expected.
I'm running away.
Well, everyone, welcome to the 95th District Court. I'm trying to get organized here with all your binders and keeping the computer in front of me. Let me begin by simply asking, is everyone here who's going to be here on Culinary International versus DSM Management Group, Inc.?
Yes, Your Honor. Brett Govett and Jackie Baker, counsel for Culinaire.
I don't want introductions just yet.
Okay.
I just want to know if everybody's here who needs to be here.
Yes.
Okay. I need to cover some stuff on the record before we get started, and it is obviously we're doing this temporary injunction hearing by way of remote participation, specifically by Zoom. It is a proceeding of court. It is subject to the open courts provisions of the Texas Constitution. The courtroom doors actually happen to be open. If members of the public were to walk in, they could come in and at least see my part. The only member of the public who happens to be here, however, besides myself, would be the bailiff, the court's bailiff. But we're also broadcasting this on the court's YouTube channel, and that creates certain issues. The participants and members of the public are prohibited from recording any part of this proceeding, and that includes copying off the live stream or the recording on YouTube without the court's express permission. The court has not signed an order authorizing any recording of this proceeding. There is one record, and one record only comes out of this proceeding. And that is the record that is maintained by the court reporter of the 95th District Court. That's Ms. Rouse. Are there any questions about that?
No, Your Honor.
I hear none. Now, someone is on area code 214, and the audio on that keeps bleeding through, and we can hear it. If you could put yourself on mute, that would be greatly appreciated. There is an alternate way to do it, but it's a little more cumbersome.
Did it do it?
That person hasn't done it, so I have muted that individual. Okay, are we ready to proceed?
Yes, Your Honor.
Plaintiff's ready, Your Honor.
All right, then let us begin with introductions, beginning with counsel for the plaintiff Culinaire.
Good afternoon, Your Honor. Brett Govett. I'm here today with Jackie Baker as my co-counsel. We're proud to represent Culinaire International, Inc. in this case. We're joined today by our client, CEO and founder of Culinaire, Richard Gassoni, who's on the Zoom link, and also William Lenore, who will be listening in, and we're ready to proceed. Thank you, Your Honor.
Now, this is an evidentiary procedure or proceeding, but am I to understand that the parties have structured your presentations to the court where we're not going to take any live testimony?
That is correct. I'm sorry, Your Honor. That is correct. Consistent with our on-the-record discussion last Thursday, we'll be offering the exhibits and the deposition testimony that have been filed in the case.
All right, so we
Your
don't
Honor,
have
from the defense standpoint, we will be presenting Vicky Martinez. We had attempted, based on agreements, to present her testimony by declaration. That has been objected to, which they have every right to do, but she is present and is prepared to provide testimony later in the hearing.
Is that the individual that is identified as V. Martinez on my screen?
Yes, Your Honor.
Is she subject to the rule? And if so, is the rule invoked? That's really why I was asking after Mr. Gavette identified Mr. Gassoni and Mr. Lenore.
Your Honor, the first point is we had an agreed order that was how we were going to structure this, and Ms. Martinez was not part of that agreed order. We agreed to whom we were going to take depositions of. We took some 10 depositions. The first I've heard about Ms. Martinez offering any sort of evidence was when we received their papers, which were filed last night after 10 p.m. We could have deposed Ms. Martinez had there been compliance with our agreed order that was submitted to the court, but there wasn't. And so if we were going to be calling witnesses, I've got a whole cast of individuals that I could call, but that was the whole point of agreeing to the agreed order and taking all those depositions, the 10 depositions in the case, was so that we wouldn't do this. I don't know what Ms. Martinez's role is. There was a unsworn declaration that was submitted last night, which we objected to because it was unsworn. And it was not part of the procedure that we had agreed to leading up to the preliminary injunction hearing, the temporary injunction hearing today. And so that's why we took issue with it.
Y'all are answering way more than I've asked at any given moment.
I'm sorry.
Is she subject to the rule? And is the rule invoked?
We would invoke the rule.
All right. Let's hear from counsel for defendant. Please introduce yourself and who you represent.
Thank you, Your Honor. Good afternoon. Robert Whitty with Anna Olin, representing the DSM Management Group. On our hearing today, you see Ken Navas, who is the president of the DSM Management Group. As mentioned, we also have Vicky Martinez, who is the vice president of finance for the DSM Management Group. We also have on the Zoom hearing, Your Honor, Jane Shane, who is the board chair for Dallas Summer Musicals, as well as Joseph Yoshitomi, who is the general manager for the DSM Management Group. Your Honor, with respect to Ms. Martinez's testimony.
Slow down. Slow down. Let's do this one at a time. All right. Who's the individual at area code 214? Does anyone know? All right, I'm asking that individual to unmute. And who is this at area code 214?
William Lenore.
Oh, so Mr. Lenore is here. I got it. He's using the, just like I believe Mr. Govett, is it? I'm sorry, is it Govett or Govett?
Govett, just like Lyle Lovett, Your Honor. Govett.
All right. I apologize. Mr. Govett, are you broadcasting one a camera and two a remotely with audio remotely or secondarily?
That we are in a conference room, Your Honor, and I have it on and it's tied through our video conference system. So that may be what that is. I'm just not certain.
All right. It appears Mr. Lenore is doing the same thing. All right. Now I know who all we have. I'm willing to hear about Ms. Martinez here for a moment without going into too deeply into anything that might impact her being placed under the rule. I'm sorry, that's my bad. Mr. Whitty?
Yes, Your Honor. Vicki Martinez is the Vice President of Finance of DSM Management Group, Inc. We had offered, the court may recall from last week, as a result of Culinair's briefing that failed to comply with the rules, Culinair agreed that DSM Management Group could provide supplemental briefing and supplemental support for that briefing yesterday. And we did, Your Honor. And as part of that, we presented a declaration of Vicki Martinez that was straightforward. It simply provided an updated financial statement, a one-page document reflecting the financial condition of DSM Management Group as of July 31, 2019, so that the court would be provided updated information as of the last month completed and financial statements prepared. It provides her current role. We think it sets forth the proper predicate for that document. However, as they have the right to do, Culinair has objected. Thus, we have her here for the purpose of testifying on that issue. Your Honor, we certainly assert that it violates in no way, shape, or form the agreed order. And, you know, it was certainly our hope and intent that testimony was not needed, frankly, as far as a live witness. But given the objection, we have her here in case her testimony is needed.
Is the sole purpose of her testimony to tell the court what the current financial and maybe cash status of MGI is?
Yes, Your Honor.
Mr. Govett, what's the objection to Ms. Martinez providing that information to the court?
Your Honor, it's as I was stating earlier, we had a lot of depositions in this case. One of those depositions was of the chairman of the board of MGI, who actually testified that he had some records with him that were assisting in his testimony. This is another matter for the court at another time, but here's where I'll link it up for you. And he testified to similar information. We've not been provided any background or any discovery on this. It's a internal only unaudited one sheet of paper that says that has certain statements on it. no background, no nothing on it, no discovery on it. So the problem that we have is there is prejudice, there is surprise because this came in last night at 10 o'clock and we've not had an opportunity to do any cross-examination or take the witness on it. And so we have a problem with it. The other problem was that we had agreed that we would not have live testimony at the hearing. And so it's our objection. If the court wishes to overrule it, I understand, but what was filed last night was unsworn. We do have procedures in the Texas Rules of Civil Procedure and the Civil Practice and Remedies Code for sworn declarations. It was unsworn, and further, it talked about generally accepted accounting principles, but there was no basis in there other than, well, I'm the CFO of the Dallas Summer Musicals, and this was prepared in accordance with generally accepted accounting principles, and it states that it's unaudited, and it's very generic and conclusory. That's our issue with it, Your Honor. And so we felt it was our obligation to our client to object to it because of those issues.
Where, I understand the surprise, where's the prejudice?
Well, the prejudice is, it comes here. If I'll direct the court's attention to Mr. Novice's, who's joining us on the screen here, deposition at page 210, lines 18 through 25. Actually, lines 18 through 25 and page 211, lines 1 through 8, and I'll read it to the court. And it's questioning by Mr. Whitty. It says, you had mentioned earlier there was a question about whether MGI had the financial resources, and I think the number was in the $4+ million amount referenced in the letter. Specific to MGI DSM Management Group, does DSM Management Group have anywhere close to that amount of money? Answer at page 10, line 25, no, they don't. Continuing on to page 11. When you answered this question, were you answering it based upon Dallas Summer Musicals finances? Answer, yes, Dallas Summer Musicals has that amount of money available. Question at line 6, but DSM Management Group has nowhere close to that. Is that correct? Answer, that's correct. So question, so when you made the statement in your affidavit, and Your Honor, there was an affidavit filed in this court.
Slow down. Now you're arguing the case. I asked where the prejudice is.
It's in this testimony where the president of DSM Management Group being testified they had nowhere near $4 million. And now we have this unsworn declaration coming in the night before the hearing that seems to indicate we have total assets and total liabilities and net assets of $4 million. So there is prejudice, Your Honor, because we had taken the deposition, the sworn deposition of Mr. Novice, where he swore under oath to questioning by his lawyer that they did not have anywhere near this amount. And now we've got something coming in that contradicts that. When we relied on this in our briefing, and frankly, it's from the president of the organization. So we consider that.
I didn't read your questioning in that deposition to be talking about total assets. I thought you were asking about cash, to be blunt.
Yes, Your
Well,
Honor.
this is Mr. Whitty's questioning.
Okay.
We did rely on that. And so as we did take that testimony to mean that, because if you keep reading further at line 9, so when you made the statement in your affidavit about DSM Management Group not having the financial resources to afford the additional IT support, financial resources, of course, Your Honor, is much broader than cash. That would have been required to produce documents in 7 to 10 days. Was that a true statement? Answer, yes, it was a true statement. And then he continues on at page 11. So we looked at it as assets cash, financial resources, however you'd like to characterize it, the ability to draw upon something to generate revenue, cash, and so forth. And that's what we relied upon. I hope that answers your question, Your Honor.
I still don't see any prejudice. I mean, if all she's going to testify to is as to the current financial status of the Dallas Summer Musicals or DSM Management Group, Inc. I mean, I don't see how there's prejudice, especially considering that one of the grounds, and in fact, I'll be blunt, but probably the biggest sticking point that this court has, and I've read your briefing, obviously, is on the issue of inadequate remedy at law, and there may or may not be. I'm not just, but it seems to me to be the sticking point as to whether or not there's an adequate remedy at law or not. And this at least touches on that. So the question is, do we take, because I understood we were going to do this without witnesses, and I was going to go through a litany of what the testimony was going to be, so that we create a record using the depositions.
Right.
Is Ms. Martinez going to have to testify live or just by an unsworn declaration, which frankly is permitted? Now, I haven't seen her declaration as
It's
to whether
just missing.
all.
I'm sorry, Your Honor.
We now have a procedure for an unsworn declaration that carries the same force and effect as an affidavit. And I don't know if hers meets that or not.
It does not.
Actually, Your Honor, I'll represent to you that it specifically meets the requisites set forth in section 132.001 of the Texas Civil Practice and Remedies Code.
If he represents that, Your Honor, I didn't see it. I think I do see the declaration under penalty of perjury now. We think it's outside the parties' agreement. I understand where you're coming from. If you want to proceed, we'd like to proceed, Your Honor. We don't need the live testimony. If the court wishes to consider this, the court wishes to consider it.
Okay.
We were not afforded the same opportunity to offer unsworn declarations from our own witnesses on various points as well. That's further prejudice. So, but I understand the court's preference. You're just saying, look, why are we taking the time? If she's going to say the same thing, I agree with you. Okay.
Then I'm not going to put Ms. Martinez under the oath at this point and invoke the rule. Let me say something up front. And my wife and I are not regulars at the Dallas Summer Musicals. In fact, not even close to regulars. We did have tickets to see Jesus Christ Superstar this year. I am personally familiar with the Dallas Summer Musicals. I'm also personally aware of Culinaire and have been a patron of Culinaire services in the past. I have that involvement as a Dallasite, frankly, has no impact on my decision making either way on this case. Similarly, by and large, this was what I have seen so far is incredibly professional, with every once in a while y'all getting in a dig at the opposing party and fluffing up your own. The court's not going to consider any of that. I understand Culinaire to be a top-notch entity in the Dallas Summer Musicals and Music Hall at Fair Park to be a top-notch entity, and I'm not swayed either way by an occasional dig at the opposing side. So that said, shall we cover what the record is?
Yes, Your Honor.
Yeah, sure.
Actually, before I do that, Y'all have given me an incredible amount of information and have organized it extremely well. Thank you. What neither one of you provided me, at least that I can find, is the proposed order that you're hoping comes out of today's hearing. Mr. Govett, please tell me what specifically the court is hoping that, or what Culinaire is hoping that this court enters at the end of this proceeding.
Yes, Your Honor, and we submitted the order just shortly before the hearing today. And so it is filed as a proposed order in the case. I should have filed it earlier. I apologize for that. We've been moving pretty quickly here, but I can read into the record the injunctive relief that we seek. It's in 2 paragraphs on page 2 of the order.
Okay, please do.
Okay, so we are asking the court to order the following injunctive relief. First paragraph, defendant DSM Management Group, Inc. and its officers, agents, servants, employees, and attorneys, together with any persons in active concert or participation with them, are directed to immediately reinstate the Food and Beverage Facilities Management Agreement and First Amendment to the Food and Beverage Facilities Management Agreement with Plaintiff Culinaire International, Inc. That's the first paragraph. So we are arguing and contending the status quo as it existed before you sent the termination letter. That is the status quo. We want maintenance of the status quo, and that is our request. And then second, number 2, defendant DSM Management Group, Inc. and its officers, agents, servants, employees, and attorneys, together with any persons in active concert or participation with them, are prohibited from entering into an agreement with another entity or person to provide food and beverage services at the music hall at Fair Park in Dallas, Texas. Those are the 2 paragraphs that are in our order that we seek with respect to injunctive relief. And of course, then we have a trial setting in the order as is required, I believe, by the rules of civil procedure, and a bond, Your Honor. And I hope it's on your system showing as shown as a proposed order. I did see it on my email.
It is not yet, and to be blunt, is not likely to be up. I mean, just the way it works, when you send something by e-filing, it's not coming. It doesn't make its way through the clerk's queue for probably 24 hours most of the time. And that's just the reality. Okay.
And we can email it as well, Your Honor, if you wish. Mrs. Baker has it handy and can email it if you wish to Miss. Okay.
I'm good right now. That's what I wanted to know. What are you asking for? Mr. Whitty, what is defendant asking for?
Your Honor, we are asking that the court deny the application for temporary injunction in all respects.
If I were to grant a temporary injunction, what sort of bond does the defendant think would be appropriate and why?
Your Honor, at this point, we would propose a $100,000 bond. If DSM Management Group is not able to bring in an acceptable food and beverage provider into the music hall to where that provider is ready to perform food and beverage services next year when the music hall reopens for the musicals, hopefully in April, if not sometime thereafter, then the cost and inconvenience to DSM Management Group and frankly to the public will be very significant. We'll address that in our argument, but in fact, perhaps one of the only upsides of this COVID-19 pandemic, Your Honor, is that we actually have a period of time where the music hall at Fair Park has no performances, no events, to where the transition from Culinaire to another food and beverage provider could be effectuated in a way that does not hinder the ongoing ability to serve the public.
Okay. Why are we proceeding on a temporary injunction rather than a permanent injunction? Mr. Govett.
Your Honor, because at the time that we got all of this together, that was the plan and it was back in May when we filed our papers. We could proceed on a permanent injunction basis, but my understanding was, based on the study and the law, was that there might be factual issues for a jury to determine that may factor into that. However, we would definitely consider conversion of the temporary injunction to the permanent injunction if all parties were agreed that that's what should be done. But that's our understanding of the law, was that this was the proper way to proceed, Your Honor, when we looked at the rules of civil procedure.
Fair enough. I mean, it is the proper way, but sometimes people jump straight to permanent injunction. So my follow-up question with you is, were I to grant a temporary injunction, when do you anticipate that a hearing on a permanent injunction would take place?
We can do it as soon as reasonably practicable, Your Honor, or if there needs to be a hearing on it, if the parties don't agree that it's just converted, then we can, then that could be agreed. I don't know what Mr. Whitty's position would be on that, but we can do it as soon as reasonably practicable.
If I deny a temporary injunction, are we going to proceed on a claim for damages at law? Is that the anticipated avenue here?
Well, if you were to deny it, I might, I'm not there yet. But yes, that is, but one aspect of that is what you just raised, and say, okay, well, maybe you want a more complete record. And I would look at the same issue in terms of, okay, well, let's have a more complete record for a permanent injunction. If that were, of course, denied, then there would be a case, then we would proceed for damages. Yes. But our hope here, I'm sorry, Your Honor.
I know you want me to grant the temporary injunction. So I'm just trying to figure out where we're moving exactly on this.
Right, and I was still addressing that. I'm sorry.
Right.
What I was saying is that if dependent on that, Your Honor, because when the lawsuit was filed, we sent a demand. The termination letter was sent on April 3rd. Very early the next week, I was notified. I sent an email and said, we're hired, freeze everything, so forth. And Mr. Whitty and I started communicating. And we didn't know, obviously, how things were going to play out. And so all I was saying is, what the future held in terms of the courts and so forth. So all I was saying is that, yes, we will if we need to, but our hope is that we would get the agreement back, as you indicated, and then there wouldn't be much of a case for damages and so forth. There would be some in terms of fees and so forth, but so that's the issue.
All right, Mr. Whitty, where do you perceive we go after today, whether I grant the temporary injunction or don't grant a temporary injunction?
Absolutely, Your Honor. Our position would be, first, we have taken 10 depositions, but they have each been limited in scope and time based upon the parties' agreement and the agreed order. Therefore, Your Honor, we would present that there will be, not only with respect to those witnesses, some additional depositions. There will likely be quite a few more. The parties did work together to try and limit the number of depositions. At one point, we were well over the number 10. And so we would certainly state that there would need to be time for additional discovery and then a trial on the merits with respect to the issues involved and with respect to the relief that Culinaire seeks, as the court has noted, likely to pursue a judgment for its damages, which Culinaire has stated that it can articulate.
All right. now, the next question is, what is the likelihood, depending on which way the court ultimately comes down on this today, that there is a movement? And I'm only asking this, it's no skin off my back to understand this. I want to know how meticulous we need to be in creating a record on an evidentiary proceeding for which we aren't taking any live testimony, so that if one of you decides to go to the Court of Appeals, there's a record for them to proceed. How likely is that? Scale of 1 to 10, Mr. Govett.
How likely is an appeal, or how likely is the record? I'm sorry.
How likely is an appeal out of today's proceeding?
Oh, I don't know.
All right.
I don't know.
Fair enough.
I just,
Fair enough. Mr. Whitty?
Your Honor, I would respond similar to Mr. Govett, except that given that MGI would be restricted by an injunction in this situation, I would think it would perhaps be more likely than 50%.
Okay. We're going to do our best then to create a record of an evidentiary proceeding without actually taking any evidence, so that it is real clear to the Court of Appeals. Are we in agreement on that?
yes, Your Honor.
Yes, Your Honor.
All right. Then let's. Yes, Mr. Govett.
I'm prepared on that, Your Honor, if it please the court, with respect to, we just submitted our deposition excerpts, and with respect to our exhibits that are already filed, we're prepared on that as well. And I have a few points, if the court wish, that we could knock out, and perhaps that addresses a good bit of what we're about to do.
Well, allow me to, that is what I'm about to do. I was going to look at the exhibits here, and it's, if I understand that, with the possible exception of what Ms. Martinez has, there is agreement on admission of exhibits. Is that correct?
Yes, Your Honor, that's what we discussed on the record with the court last Thursday.
Yes, that you did. Now, Mr. Whitty, the court has received one binder from plaintiff, two binders from defendant, two sets of binders, I should say, from defendant. The second set of binders is essentially a duplicate, correct?
No, Your Honor, the second binder would be.
Not the second binder. You sent me two binders and a duplicate, two binders.
Yes, Your Honor, one of those is for the court reporter.
All right. So whichever one I keep is the official set of exhibits that have been tendered, and I understand the Cullen-Air binder is the official set of exhibits to be kept. Is that correct?
Your Honor, yesterday, that is the official set with respect to our motion papers, and with respect to our, yes. Yes.
I'm going to go, let's go through this, gentlemen. What I have from plaintiff is an exhibit 1, exhibit 2, exhibit 8, exhibit 9, exhibit 14, exhibit 17, exhibit 20, exhibit 21, exhibit 23, exhibit 24, exhibit 25, exhibit 33, exhibit 37, exhibit 39, and exhibit 45, exhibit 51, exhibit 57, exhibit 74, exhibit 83, exhibit 85, exhibit 94, exhibit 96, exhibit 102, 103, 104, exhibits 107 and 108, exhibit 115, 117, 118, 120, 121, 124, 126, 129, Exhibit 130, 131, 132, 133, 134, 135, 136, 137, 138, 139. Exhibit 141, 142, 143, 144, 145, 147, Exhibit 150, 151, 152, Exhibit 301.
300, Your Honor?
Excuse me, Exhibit 300, 301, 302, 303, 304, 305, 306, Exhibit 311, 313, 314, 315, 320, 321, 322, 323, 325, 329, Exhibit 331, Exhibit 332, 333, 334, and 335. And we'll get to your supplemental exhibits here in a minute. Is plaintiff offering the exhibits I just stated?
Yes, plaintiff offers the exhibits you just read into the record, Your Honor, and requests a ruling on the admissibility of them, please.
Mr. Whitty, is there any objection to any of the exhibits I just stated?
Your Honor, subject to Culinaire equally agreeing to the admissibility of our exhibits,
All right.
we would not object to their admissibility.
Fair enough. I understand that. So I will consider those Culinaire's first set of exhibits, and I'll issue a ruling on that in a moment. Defendant has submitted the following exhibits.
Your Honor?
Yes.
May I just ask Mr. Whitty something? We didn't get the binder, at least that if he emailed it, I'm just asking where I can find those.
It was my understanding you had the binder, but I will follow up and confirm where that is, Brett.
Okay, because I don't know what they are. That's the
Well,
problem.
they are all cited too within our briefing.
Okay, here's what I have from the defendant. An Exhibit 51, Exhibit 108, 115, 201, 202, 211, 212, 213, 214, 215, 217, 222, 228, 229, 230, 231, 232, 233, 234, 235, 244, 245, 247, Exhibit 250, 251, Exhibit 261, 262, Exhibit 268, 275, 276, 279, after 276 is 277, 278, Exhibit 319, Exhibit 512, 517, 540, 557, 560, and 562. I also understand there was well, let's address those. There may be one more floating out there that was Miss Bates labeled, and we'll get to that in a minute. Is the defendant offering the exhibits that I just stated?
Yes, Your Honor, and we seek a ruling as to their admissibility.
All right. Does plaintiff have any objection to the exhibits just stated?
I'm fine with the ones through around 300, Your Honor. May I ask counsel, were they all deposition exhibits? Because the problem is
Yes.
I didn't have a copy of them.
Yes, they are all deposition exhibits.
including 512, 517, 545, 57, 567, and 568.
Yes.
Can you just tell me what deposition they're exhibits to, please? If they're all deposition exhibits, there's not an issue. I just want to check one thing real quickly.
Which one in particular?
The 500s. Do you have this deposition exhibits?
517 was the February 15th, 2019 summary of the Fessel report prepared by Joseph Yoshitomi.
Can you say that name?
Joseph Yoshitomi, Yoshitomi.
Thank you.
And 567 and 5, sorry.
Number 512 was the exhibit 512, Bates number MGI 0006578 through 0006580. It was the email chain between Ken Novice and Mary Westfall dated December 3rd, 2018 regarding the Chairman's Lounge.
Okay, I see them. And I'm sorry, 567 and 568. Would you just tell me what those are, please?
It was 557.
Correct. 557 was the email communication between Joseph Yoshitomi and William Lenore in June of 2019 with respect to an employee named Mary.
And the last two that the judge read off, I'm sorry, I just thought I wrote it down.
560 is from Culinaires.
Last two.
It is not, it's basically Culinaires comment cards for July 28, 2018.
Okay, on the basis of the representation that they're all exhibits to the deposition, Your Honor, it's fine. There's no objection.
All right. Each one of the exhibits that the court mentioned by number is admitted. I've also got before me exhibits 336, 337, 338, 339, and 340. It was the 340 one that was Miss Bates labeled at one point as 440, I believe. So
Yes.
we've got 336, 337, 338, 339, and 340. Is plaintiff offering those exhibits?
Yes, Your Honor. Plaintiff offers those exhibits into evidence and requests a ruling from the court on their admissibility, please.
Any objection from defendant?
No, Your Honor.
Exhibit
Your Honor,
3.
if I may I ask one question on plaintiff's exhibits? I have exhibit 274 and need to see if that document was part of the initial round of exhibits that we discussed.
All right, well, let's address these right here. You have no objection to 336 to 340, correct?
No objection, Your Honor.
336 to 340 are admitted. And what was, Mr. Whitty, what was the one you were asking about?
274, Your Honor. And Brett, that is the April 18, 2019 email communication between Joseph Yoshitomi and William Lenore.
It's not ours. It's not part of what we offered.
I do not see that 274 has been presented by any parties.
And Your Honor, we will provide this to the court And Brett, just so you have it, it's MGI 0009900 through 0009901. It was utilized at a number of depositions. Again, it's communication between Joseph Yoshitomi and William Lenore, dated April 18, 2019, with respect to the subject line being improvement project tracker.
Which deposition was it, an exhibit to? I'm sorry.
I know it was an exhibit to a number of depositions. I will get that to you.
Okay.
1 second, counsel. You are correct. Oh, my bad. Thank you. I will rework the order and get it to you.
Okay.
Come back in about 3 minutes. I'll have it signed.
Oh, okay. I'll put the hearing on.
Sorry, counsel. Court clerk has just presented me an order on another case that needs to be redone, and it is redone. So we have the question about Exhibit 274. I hesitate to offer it without it being in front of me, or I hesitate to admit it without it being in front of me from a record standpoint. Can someone email that to Ms. Rouse?
Yes, Your Honor, we can.
Okay, we will
Yes,
hold
Your Honor.
off. We will hold off on admitting 274, but lest there be any doubt, and I think I've done this, but I want to make sure the record is absolutely clear. The court has admitted the first set of plaintiff's exhibits that were recited. The court has admitted the entire set of defendant exhibits that were recited, and the court has admitted 336 through 340. Other than 274, are there any other exhibits that we're going to pre-admit?
Not in terms of exhibits, I believe, Your Honor. We will tender deposition testimony, but not in terms of exhibits.
Correct.
Now let's talk about the deposition testimony. That was where I was going next. My training always was that deposition testimony is testimonial evidence, not evidentiary evidence. That said, we're trying to create an oral hearing record with testimony, and doing so by way of simply in bulk offering depositions. The parties have presented the court with, I believe it's 10 depositions. I can read them by name. How do you wish to proceed in 3 sentences, Mr. Govett?
We offer the deposition testimony in either excerpt or whole. I hope that answers your question.
Sort of. Mr. Whitty, how does the defendant wish to proceed?
Your Honor, although I think both parties have presented excerpts for the court's benefit, we would wish to proceed offering the deposition testimony in their whole for purposes of the record.
I'm inclined to do that because I don't have, what I've got from both of you are something akin to full sets of the depositions with some highlighting. And the solution I came up with, and I'm open to suggestions on how to tweak this, as I have before me the set of depositions that were presented by the defendant. The reason I'm choosing that set, to be real blunt, is I don't want the Court of Appeals to be mad at me for sending over the condensed versions. And that's I have before me William Lenore's deposition taken August 12, 2020. Mr. Lenore's deposition continuing on August 14, 2020. Mr. Novice's deposition on July 31, 2020. Mr. Rules, R-U-E-L-E, Mr. Rules' deposition on August 11, 2020. Ms. Schoen's deposition on August 14, 2020. Mr. Schulte, S-C-H-U-L-T-E, Mr. Schulte's deposition on August 7, 2020. Mr. Thompson's, T-H-O-M-P-S-O-N, Mr. Thompson's deposition on August 12, 2020. Mr. Watson's deposition on August 14, 2020. Mr. Yoshitomi's deposition on August 13, 2020. And Mr. Epstein, E-P-S-T-E-I-N, Mr. Epstein's deposition on August 4, 2020. Except, unfortunately, those aren't entire sets of depositions, or at least some of them aren't. And I just realized that as I was reciting them through. It's excerpts. How do you wish me to handle these? Mark them as exhibits and then?
Your Honor, as part of the appendix that we commented on last week, I do believe that Culinaire has filed the complete transcripts of the depositions that you have mentioned. We would be agreeable to accepting those transcripts. Mr. Govett did mention last week that they did not file, and I think appropriately so, the confidential portion of Ms. Shane's deposition. And we have filed that separately. And so we would be agreeable to having the deposition transcripts that were filed in their entirety by Culinaire accepted by the courts, along with the separate filing that we submitted of the confidential portion of Ms. Shane's deposition.
Mr. Govett is
That's,
are you
that's fine.
happy with that?
Yes, Your Honor. Yes, thank you.
All right, then what we are going to do, unless you gentlemen have a better proposal, I'm going to mark Mr. Thompson's August 12, 2020 deposition as Exhibit Court 1. Mr. Munsell's, M-U-N-S-E-L-L-E, Mr. Munsell's deposition of August 4, 2020 as Court Exhibit Number 2. Ms. Schoen's deposition, is it Schoen or Shine? I apologize.
It's Shane, Your Honor.
Ms. Shane's deposition of August 14, 2020 as Court 3. Now, do I understand that there are some portions of Ms. Shane's deposition that is now Court 3 that is has been removed?
Yes, Your Honor. There was a portion of her testimony that at the time was provided subject to the agreed confidentiality order between the parties. And so we have filed that portion of the transcript separately.
Okay. We will address the other portion here in a minute. Mr. Novice's deposition will be marked as Court 4. Mr. Lenore's deposition will be marked as Court 5. Mr. Epstein's deposition will be marked as Court 6. Mr. Yoshitomi's deposition will be marked as Court 7. Mr. Rule's deposition will be marked as Court 8. Mr. Watson's deposition will be marked as Court 9. Mr. Schulte's deposition will be marked as Court 10. Mr. Lenore's August 12, 2020 deposition will be marked as Court 11. And where do I find the extra portions of Ms. Shane's deposition?
Your Honor, it was filed as the appendix to our supplemental brief, and it was also hand-delivered to the court this morning.
Oh, all right. I haven't gotten it this morning. Let me see if your supplemental brief has come through. Unfortunately, it has not come through on the. You believe it was hand delivered today?
Yes, Your Honor.
All right. I'll address that in a minute. We're going to take a break anyways. On courts 1 through 11, are the parties in agreement that those are considered and are admitted as testimonial evidence in this cause as part of this hearing? Mr. Govett?
Yes, Your Honor.
Mr. Whitty?
Yes, Your Honor.
Excellent. Is there any, and I understand during argument, you're going to take me through what you believe are the important parts of those testimony. Is there anything else to consider for admission at this time?
The only thing I would ask, Your Honor, is we have them admitted. We would just request agreement that the exhibits and the deposition testimony are properly part of the record of the temporary injunction hearing. I think we're there, but I just want to get that on the record, please, for obvious reasons.
That's what I was intending there, was that this is the record from this temporary injunction hearing. All of those exhibits and all of that evidence that I just recited.
Yes, Your Honor.
All right.
Yes.
And you all have raised a point in absolutely in passing that I noted getting ready for today. The parties have an agreed protective order, most extensive protective order I may have ever seen. And it does not appear to me that any of my predecessors sitting by assignment ever signed it. Are you aware whether or not a signed copy of the agreed protective and confidentiality order was ever entered?
We never received a signed copy, Your Honor.
Agreed, Your Honor.
I didn't hear what Mr. Govett said.
We never received a signed copy, Your Honor.
Okay. Are the parties requesting that the court sign the agreed protective and confidentiality order that was submitted back in mid-July?
Yes, Your Honor.
Yes, Your Honor.
I'm doing so. It has been signed. Okay, before you present your arguments on this, Is there anything further we need to consider from an evidentiary standpoint?
Not from the plaintiff's side, Your Honor.
Subject to the issue of Vicky Martinez, nothing else from the defendant's side, Your Honor.
Okay.
Other than the additional portions of the Jane Shane deposition, which for purposes of this proceeding, we would be willing to offer without the restrictions on confidentiality within this proceeding.
Okay. Well, let me get my hands on that. I'm going to go, we're going to take a break. I'm going to go ask the clerk what's pending in the queue so that I'm not operating at a deficit. And then see if the hand delivery came from you this morning that hasn't made its way to me. It's probably in an inbox somewhere. Yes, Mr. Govett.
We had a hand delivery to you as well, Your Honor, our slides that we intend to take the court through.
Was that the hand delivery that included 336 through 340, or was there something after that?
It's something, it came today, Your Honor. It would have been brought down today.
All right, I will find out what is there. And how do you anticipate proceeding now when we get to argument here?
Your Honor, we would run through the slides, answer any questions the court may have either during the course or at the end, and then obviously listen to their argument and respond. And then I guess we'd be done and be under submission if the court did not rule today.
All right. I mostly meant how long is your argument going to be?
Oh, it should take around 45 minutes or so, Your Honor.
Very good. And you have it, I take it from what you said, you have a PowerPoint that you wish to share screen on?
Yes, Your Honor.
All right, Mr. Whitty, how do you anticipate proceeding?
Your Honor, similar, we would propose to share screen, and I would anticipate our argument to be in the neighborhood of 45 minutes.
All right, very good. Let's take a 10-minute break. I will go ask the clerk what there is, and then we'll come back and we will reconvene at 3:16. How's that sound, gentlemen?
It's great. Thank you, Your Honor.
You're welcome. Oh, Mr. Whitty, real
Yes,
quick,
Your Honor.
send Ms. Rouse anything about Ms. Martinez's the exhibit or the declaration or whatever, so that we can consider it that way. So I'm looking at whatever it is that we have to rule upon.
Yes, Your Honor, we will do.
All right. Thank you.
Thank you.
We are off the record till 3:16. What's that?
I said, I don't know how you do it.
Well, this one's, I've been preparing for this one.
There you go.
On 6th Street, one no. Oh man. Did you get copies of the plaintiff exhibits to keep for me?
So I just sent you a text.
Oh, did you? Okay.
Yes,
Sorry, I was putting in some names into my real time.
understand.
And yes. Very clear. I did receive Exhibit 274 from Defendant's Counsel.
Very good. Will you forward to me?
Yes, I will. I didn't. Well, I didn't forward. I forwarded you a PowerPoint presentation also. Let me send you this.
Oh, I've already got, is that the Norton Rose Fulbright PowerPoint or is it defendant's?
I think so. Let me go back and look.
I've got 2 copies that were just hand delivered to me of the plaintiff's PowerPoint.
Okay, yes, that was the one I just forwarded was Colliers. And then I just forwarded you Exhibit 274. Why there's 2 of Mr. Whitty. Like 2 screens for some reason.
One is just where I'm sitting. The other is the podium that I'll use when making argument.
Okay.
Counsel, are you ready to proceed?
Yes, Your Honor.
Just, I mean, this trying things where we're all remote, especially with an exhibit quantity like we're dealing with. Again, I applaud both of you for what you have done. I am sticking actual exhibit stickers in the binder that was presented to me by, we're back on the record, Ms. Rouse.
I was talking.
I'm actually putting physical exhibit stickers on the deposition transcripts, as I read out earlier, from the depositions that were provided by plaintiff, the transcripts. So I'm marking as courts 1 through 11, those deposition transcripts, so that the record's clear, and this binder will, along with all the exhibits, go to Ms. Rouse as the official record in that regard, along with Mr. Whitty's binder. I also understand there's a 274 that is been emailed, and as soon as I get it, I will see that that is added to this official list of exhibits. I have, in the last few minutes, been advised by the clerk that there were several things. She actually had an exclamation when she saw the things that were in the queue that she is pushing toward me. And Mr. Whitty, I have not received a hand delivery that anyone could find from your office today. I did receive Culinair's PowerPoint presentation in a binder, so.
We will follow up, Your Honor. I saw it go out the door quite a while ago today, but we will follow up and see where it went.
Very good. Mr. Govett, are you prepared to begin argument?
I didn't hear any sound.
I didn't hear a thing.
Can you hear me now, Your Honor?
Yes, yes, Mr. Govett.
We're prepared, Your Honor. May we share a screen to put the PowerPoint up?
You may. Is Mr. Whitty ready?
Yes, Your Honor.
All right, well then let us proceed with argument.
Thank you, Your Honor. This is Culinair's PowerPoint. If we look at slide 2, Your Honor, it's simply laying out that we are entitled to temporary injunctive relief in this action. There we go. We've established a probable right to relief on a breach of contract claim on the basis of the objective criteria, Your Honor. The objective criteria very clearly demonstrate that MGI terminated the agreement with Culinaire without a basis. There was an average rating on the reviews of 4.5 stars with over 1,400 reviewers. There was increased per capita revenue from 2017 to 2018 to 2019 for the past 3 years. Of course, 2020 was interrupted because of the pandemic. And there was $70,000 spent by MGI on donor dinners, which the chairman of the board of the musicals said were lovely. And Mr. Yoshitomi, who's at issue here and has been deposed, said were quite good. And our exhibits here are 151, 331, 141, 323, and Mr. Lenore's deposition at volume 2, pages 223, lines 22 through 226, line 3. Second point here is that Culinaire will suffer imminent irreparable harm without an injunction. There is, as part of the record in this case that we learned about after our initial briefing, MGI had entered into a memorandum of understanding and which contained an agreement to agree with a company called Spectrum out of Houston. And they want to replace us. And they also want to replace us through an RFP process that's been mentioned even here today. So there is clearly an intent to replace Culinaire that will disrupt our business. It will remove us as the exclusive provider at the Dallas Summer Musicals, where we've been since 2008 for 12 years. And of course, there's a threat to our loss of reputation there. We have an excellent reputation. In support of this, we'd cite exhibits 336, 337, 338, 339, Mr. Rule's deposition at 102 lines 22 through 103 line 15, and page 130 lines 4 through 12. There is no adequate remedy at law, Your Honor. The music hall is shut down. There's no current revenues. There's insufficient funds to pay a damage award. This is proven at exhibit 329, Mr. Novice's deposition at lines 210 through, page 210, lines 22 through 25, Mr. Watson's deposition at page 45, lines 3 through 4, and page 13, lines 12 through 16. There's another issue, Your Honor, with respect to the calculation of damages, which we would submit are very difficult to quantify for this reason. We don't know when the music hall will open back up. When it opens back up, we don't know what the revenues will be. So if you don't know when it will open back up and you don't know what the revenues will be, obviously we believe that meets the prong with respect to the damages being difficult to calculate. Yes, of course, you can get an expert and use the past to project forward. But again, it goes to that prong, and the case law is very much on point here, that when you can't just say, oh, it's this, then it meets the prong about no adequate remedy at law because it's quote unquote difficult to calculate. Incalculable is the language that they use. But of course, if we get an expert, we will be able to calculate it. Now, Culinaire, as the court indicated, is familiar with Culinaire. We've been the exclusive food and beverage provider at the Music Hall since 2008. We also provide food and beverage service at the Meyerson Center, the Tobin Center for Performing Arts, the Belo Mansion across the street from where I am, the Bush Library here in Dallas, and the Fort Worth Zoo. That's at Exhibit 1, Exhibit 305, Mr. Thompson's deposition at page 11, lines 14 through 15, and page 185, line 21 through 186, line 14. DSM Management Group, Inc. manages the Music Hall at Fair Park. They're a subsidiary of Dallas Summer Musicals, Inc. And we believe very clearly they breached the agreement with Culinaire on April 3, 2000 by terminating Culinaire without cause. We would cite to Mr. Mansell's deposition at page 13, lines 3 through 20, and Ms. Shane's deposition, pages 18, lines 16 through 20, and page 19, lines 5 through 7.
Do those deposition excerpts go to the termination, or do they go to the without cause?
Mr. Mansell's is without cause, Your Honor. Ms. Shane, Mr. Mansell, by the way, is the former chairman of the board of the Dallas Summer Musicals. He wrote the email that said we did a great job to Mr. Schulte. And Ms. Shane is the one who testified about the subsidiary, I believe, that it's in a subsidiary relationship. The key players involved, Your Honor, on the next slide, slide 5, this is who everybody is. Mr. Navas came in on May 1st of 2017, and then that's when things began to set into motion. He signed the agreement in June of 2017. His testimony is that he didn't follow the standards in signing it, that he should have run it past the entire board. He didn't do that. And so we believe it's pretty clear that he had a bad taste in his mouth with respect to the signing of the agreement, wanted to get rid of it, and spent the rest of the 3 years working on that, he and Mr. Yoshitomi. He started on May the 1st of 2017, as I indicated. Mr. Yoshitomi is the Vice President of Operations at Dallas Summer Musicals. He fulfills a role with MGI, first as a contractor, and then starting in January of 2019, we believe he's the Vice President of Operations at Dallas Summer Musicals, but he also does work for MGI. Mr. Watson is the current board chair of MGI, Ms. Shane, the DSM board chair. Mr. Epstein was the board member. He's the one that sent the email when he learned that we were terminated that said he was dumbfounded, and he also had his 80th birthday party at the music hall in December of 2019 and said it was a great event. He worked on the negotiation of the agreement with Culinaire and the remodel that's at issue here, because when we signed that agreement, we agreed to remodel the place up to $375,000, which did not include our time, and freshen it up in advance of Hamilton performance, which was coming to town in August of 2019. Mr. Munsell, of course, is the board chair and was the chair of the DSM board when the extension was signed. On the Culinaire side, Mr. Lenore is essentially the Culinaire officer that was in charge of the music hall. Mr. Schulte was the food and beverage manager. He's the one that received the email from Mr. Munsell that's saying, hey, look, you guys did well by me. Mr. Rule took Mr. Schulte's place when the music hall asked that Mr. Schulte be replaced in writing. We replaced him in compliance with the agreement. Mr. Thompson is the president and chief operating officer of Culinaire. If we look at slide 6, Your Honor, Exhibit 1 is the food and beverage facilities management agreement. It was entered into July 1 of 2008, and it gives us the exclusive right to provide the food and beverage service. There's only one provider, and there can be only one provider over there because of the way things are set up.
Kirk, how are you?
Hey, you're on mute.
Sorry?
Oh,
You're on mute.
there it is. Sorry, I don't use this as much as I should.
Oh.
Hey, you're a pro at it.
Richard,
No,
can
I
you put it
just-
on mute, please?
Somebody
You
is,
look like you're in your office.
I'm in the office. We have a
who is
trial
this?
that's going on, so I have to be dressed on the court. You know,
Mr. Gassani, could you put it on mute, please?
we'll see how that works.
I'm not sure he can hear me, Your Honor. That's Mr. Gassani talking. It came off of mute for some reason.
Yeah, I can't mute them when we're on share screen.
Oh, okay. Mr. Gassani, can you put your, can you put it on mute, please?
I just did.
Okay, there we go. Okay. So, Your Honor, we're on slide 6. The First Amendment was executed is Exhibit 17. It was effective July 31, 2017. It extended the term of the agreement out to the end of July 2028. And a key point here is the title of the improvements. When Culinaire first came onto the music hall in 2008, they provided improvements at that point in time. Title to those improvements was in Culinaire. When the new agreement was executed, the title moved from Culinaire to MGI, and the new improvements would also be in MGI. And there's that $375,000 that I mentioned with respect to the improvements. And critically, if you terminate it for any reason, you had to pay the unamortized amount within 15 business days, and that's not been done. Slide 7, these are the exclusivity provisions from the agreement. I won't spend a lot of time on them. Section 2.1 of the agreement, of the original agreement, and section 8.1 is key because 8.1 has a covenant of quiet enjoyment, which was violated. MGI brought Spectrum onto the premises into the kitchen area before Culinaire was terminated with the intent of MGI taking over from Culinaire. And there was no notice to Culinaire that this was happening, and they obviously had not been terminated at that point in time. Slide
Did you
8.
mean did you mean with intent of Spectrum taking over for Culinaire? You said with respect to MGI taking over.
I'm sorry, Your Honor, I misspoke. Yes, Spectrum taking over for Culinaire.
Very good.
Yes.
All right.
Thank
Proceed.
you. Slide 8, this is the termination provision. We'll get to the law part of it in a minute, but the standard is material mismanaged. And the reasonable judgment, of course, is an objective standard, which is why it's so critical that we looked at the objective criteria of the ratings and the revenue and even what they had to say with those donor dinners. And we'll get to the definition of materially mismanaged in just a minute, but it's not just, well, we can terminate you if we wish. Slide 9 is the First Amendment with respect to the term about the unamortized amount shall be paid within 15 business days following the date of any termination. And of course, the termination notice was sent on April 3rd of 2020, and there's been no payment as we sit here today. Slide 10, this is the title vesting in MGI, that the all equipment, furniture, furnishings, and smallwares purchased or provided by Culinaire shall be vested in MGI. That was a critical provision. Slide 11 is Exhibit 17 at Section 5.3. This specifies the $375,000 capital improvement that Culinaire made, which again did not include Culinaire's time. Mr. Lenore spent a lot of time dealing with this, Your Honor. So if we look at slide 12, this captures Exhibit 2, Exhibit 9, and Exhibit 21. Why did MGI commit to a 10-year extension of the agreement? Well, because the music hall needed a facelift, this portion of the music hall, before the 2018-2019 Hamilton season. And the agreement with Culinaire, the original agreement, was set to expire in June of 2018. And of course, the season begins in the fall. And so that allowed time to get the improvements up and running in time for the season, which would include Hamilton. So if there was no extension, MGI would need to bring in a new provider midway through the 2017-2018 season, more likely towards the end of it when the contract expired. So it knew that it needed to agree to a 10-year extension because anything less than that wouldn't give MGI the funding it needed, because the $375,000 is tied to the 10 years. If you're only going to go out 5 years, we'd only do half that or less. And they would obtain title to improvements so that they would have them for the future. Under the old agreement, as I previously said, Culinaire held title to all of those improvements. And that's captured in Exhibit 21. This is an email communication between Mr. Epstein, who I mentioned earlier, who was on the board, and he was on a committee of the board in the 2017 time period dealing with this agreement. And he states, we might have done a 5-year extension instead of 10, but it would not have been consistent with our goal because we only would have expected about $185,000 of improvements, which was not enough for what was needed for the restaurant and the bistro. And the date of this, Your Honor, is about a month and a half to 2 months after Mr. Navas first started. So what happened? We've got a number of issues in 2017, 2018, 2019, and 2020. 2017, there's this caveat that we never knew existed until this litigation, and frankly, it didn't exist because we never received a copy of it and no one can find it. It's not surfaced in the litigation to date. There's an audit which found no breaches of the agreement, and then that didn't work to get rid of us. So in 2019, they kicked in an improvement plan. This is what Mr. Yoshitomi came up with in 2019. And then of course, in April of 2020 was the termination letter. So the caveat, Your Honor, is Mr. Navas, it's covered in Exhibits 20, 24, 23, and 150. And Mr. Novice said that, well, I signed the extension agreement with a caveat that if we weren't satisfied, we could make a wholesale change. And we needed to consider other vendor options, and we can explore options with Mr. Whitty, who's here with us today, should we not be satisfied. So he's already bringing in counsel just shortly after signing the extension agreement. And Mr. Munsell had to tell him, listen, and this is Exhibit 150, quit talking about that caveat. It doesn't exist if we sent Culinary a signed copy without it. And that's exactly what happened, Your Honor. On slide 16, this is Exhibit 25. Some of the board members wanted to consider other providers. And here you have reference to Spectrum Concessions. And that's Mr. What's Randy's last name?
Right.
Randy Wright, who was the board last year. This is reference to Randy Wright. We haven't taken his deposition yet, but if we fully intend to, should this continue on, and he's got some connection or some affinity towards Spectrum. And of course, that's who they eventually entered into a memorandum of understanding with before giving us any sort of termination notice. This dates all the way back to August of 2017. Mr. Epstein telling Mr. Novice, listen, we've considered all that already. Slide 17, they hired Fessel, which is the search firm. This is covered in Exhibits 311, 313, and Exhibit 51 at page 6. Importantly, they got this audit, and supposedly the purpose of the audit was to help us. We never received a copy of the audit until discovery in this litigation. So the purpose of the audit, Exhibit 311, was to determine whether there was any lack of adherence to the contract. And the signed agreement with Fessel, which we never saw until the litigation, states that the client is open to considering a renegotiation and or a contract revision, as well as being open to considering a formal RFP process depending on the findings. Again, we're under contract exclusive contract during this time. And as part of this audit, Fessel reviewed the potential opportunity with several operators to determine high-level interests. We believe one of those, we've not taken their deposition yet, is Spectrum. Yes, Your Honor.
Who is client in that Exhibit 313?
MGI, the music hall. They are the client of Fessel who conducted the audit. It's not
So
Culinary.
Fessel's a third-party consultant doing an audit.
Yes, Your Honor.
All right.
And they're trying to, we believe, the evidence is quite clear that they are trying to find breaches of the agreement with Culinary, and they didn't find them. And if you look at page 18, Exhibit 57, Exhibit 57 is an email back and forth between Mr. Novice and Mr. Yoshitomi, and the all caps is Mr. Novice, where he asked, does Fessel believe that we have fair grounds to request renegotiation of this contract, ? Are there clear breaches that we can cite as why we're requiring a new contract? There were none. If we look at the next slide, slide 19, Mr. Yoshitomi's deposition testimony at page 115, lines 5 through 7. The Fessel report did not identify any breaches, did it? Answer, no, it did not. If we look at slide 20, that didn't work. So then they moved to this performance plan, improvement tracker, whatever you want to classify it. Other than bi-weekly meetings between Mr. Lenore and Mr. Yoshitomi, there was nothing formal about this. It was a Google Doc spreadsheet that now they claim was a formal performance improvement plan. This exhibits 320, 321, and Mr. Lenore's deposition at volume 2 at pages 219, line 4 through 215, line 4. Mr. Yoshitomi at page 252 of his deposition admits this plan was outside the contract with Culinary. It was not in the contract. He admitted the contract does not require a performance improvement plan. And in fact, in the entirety of page 252 of his deposition, he admits to this at lines 1 through 6, where the contract does not require a performance improvement plan. And where I ask him at the bottom, there's nothing in the contract about a performance improvement plan, right? At lines 20 through 22, and at line 25, he answers right. So what do they do? In the letter dated November 22, which is a notice letter, the opportunity to cure, they rely on a non-contractual performance improvement plan to support grounds for objection. And of course, this is copied over into the termination letter, which is sent in April of 2020. See it right there. So exhibit 20, slide 20.
Fortunately,
Judge, you cut out.
no, he cut out,
Oh,
or was it me?
I thought you started to say something.
Well, I started with unfortunately, you're cutting out in a significant way, Mr. Govett. But is it on my end?
Yes, sir.
Okay, very good. Continue. I'm
Your
following,
Honor,
but it's tough.
Okay, I'm sorry. I can see your bars in the lower left-hand corner of my screen, and they're strong now, but they do go to yellow to red occasionally. And so I'll try to keep my eye on those
right.
bars, and I will. They're
You're
red.
good.
Can you hear me?
I can hear you quite well.
Okay. Slide 23 is the request for injunctive relief. This is what you asked about early on, Your Honor. These are our two paragraphs. Require MGI to reinstate the food and beverage facilities management agreement with Culinaire and enjoin MGI from contracting with another entity or person for the provision of food and beverage services at the music hall. Slide 24, this injunctive relief, Your Honor, preserves the status quo. It preserves the relationship between the parties that existed before MGI breached the agreement by sending the termination notice. And we cite the Transportation Company versus Robertson Transportation Inc. case here. The status quo is the last actual peaceable non-contested status which preceded the pending controversy. The Universal Health Services v. Thompson case at 24 Southwest 3rd, 570 out of Austin in 2000 is very instructive, Your Honor. If an act of one party alters the relationship between that party and another, and the latter contests the action, the status quo cannot be the relationship as it exists after the action. Here's why this is important, Your Honor, because we believe that on December 18th of 2019, that's when they made the decision they're going to terminate us. They just didn't tell us for another about 4 to 5 months, because after that, that's when Mr. Yoshitomi started calling Spectrum. He visited Spectrum down in January of 2020. He entered into the agreement with Spectrum that we put before the court on February 26, 2020, which is an agreement to agree. So the status quo is the last peaceable non-contested status, and that is before they made the decision that they were going to take action against us, and that's consistent with our relief.
And
So
you're saying that line of cases provide that I can order a reinstatement as
Yes.
part of the temporary injunction.
Absolutely, Your Honor, and it's prohibitive, not mandatory. It's prohibitive because all it does is restore the parties to their original status quo position before they made the decision to do what they did. That's all it does. And that is the status quo. Okay.
Understood.
Now, okay, thank you, Your Honor. Now, if we look at slide 25, these are the basis, the cause of action, probable right to relief, and probable imminent and irreparable injury. I know you're familiar with that case, the Benario v. Ford case. Can you hear me, Your Honor?
Yes.
Okay, out of the Texas Supreme Court. And here's a key one as well, Your Honor, the Loya case. The legal issues before Your Honor at a temporary injunction hearing are whether the applicant showed. So it's whether we show, not what they do. It's whether we show a probability of success and irreparable injury. The underlying merits of the controversy are not presented. And that's Hornbook law in the state of Texas, and it's from the Dallas Court of Appeals as well from 2004. Slide 26, to establish a probable right of recovery, we need not establish that we will finally prevail in the litigation. All we need to do is present some evidence that under the applicable rules of law tends to support our cause of action. And we believe, Your Honor, we have gone above and beyond the call of duty with respect to that. If we look at slide 27, the wrongful termination, a defendant's improper termination of a contract is a breach as a matter of law. That's the Pinnacle case out of Dallas Court of Appeals in 2009, 309 Southwest 3rd at 93, pinpoint citation to page 99. Slide 28, they terminated the agreement without cause. Section 6.2D is the provision I covered earlier, the reasonable judgment, but the law on that is that they act in good faith when exercising reasonable judgment, and it's with respect to an objective standard, whether the performance would satisfy a reasonable person. And again, that's why I keep going back to the objective criteria, the ratings that are public from over 1,400 individuals, the financial performance, and what they themselves said about our donor dinners, which were lovely and quite good. Material mismanagement, this is from page 24 of our opening brief, Your Honor. It means wrongly or incompetently to a significant degree. That's not us, wrongly or incompetently. You wouldn't have a 4.5 rating if we had been managing wrongly or incompetently. You wouldn't have increased revenue. You wouldn't have these glowing comments from the chairman of the board of DSM and from Mr. Yoshitomi about our donor dinners. We couldn't do anything right if we were wrongly or incompetently managing to a significant degree. It would be reflected in objective criteria. It is not. With respect to the performance plan, we completed, this is exhibit 321 on slide 30, Your Honor. We completed most of those tasks. 7 of them were the ones that we had not completed, 7 were in progress. 1 was awaiting research, 1 was transferred, and 5 were awaiting discussion with Mr. Yoshitomi. At slide 31, these are our ratings here, Your Honor, for the various performances, and you must average them out, of course, because what the defendant attempts to do is take comments solely from one performance in August of 2019 and focus on those instead of looking at the big picture, all 1,400 of them and where they come down to. 4.5 stars is an excellent rating. That's Mr. Rule's testimony. He's a certified chef. He's a graduate of Le Cordon Bleu Institute, and he took Mr. Schulte's place in 2020, but he took his place after they had made the decision to replace us, and they never really gave him an opportunity. His testimony is at page 115, line 21 through page 116, line 20, and even Mr. Novice admits that generally a 4 or 5 stars is a good rating, and we all know that. That's at page 174, lines 9 through 25. In fact, our ratings are on par with top restaurants and performing arts venues in Dallas, and that's documented with exhibits 152, 332, 333, 334, and 335. Your Honor, we're right there with the mansion, and we're above the French room, and this is a buffet. And so that's pretty impressive, and especially when you consider the ratings with our sister operation, which is a different operation at the Meyerson. We actually rate higher than the Meyerson, and we're right there, in fact, with the Bush and so forth. So these are excellent ratings. It's slide 32. These are the small dinners. They paid us some $70,000 for these small dinners. And if you look, Your Honor, they had 4 small dinners in the March 10 through 10, 11, and 12 time period, right before government shutdown due to the coronavirus. Right before the shutdown, there were 4 events, and we cite the testimony from Ms. Shane that said the donor dinners was lovely. That's at her deposition, page 69, lines 6 through 10. Mr. Yoshitomi's testimony is that Culinaire did it well. That's at page 30, line 17. And they wanted to say, well, that was a completely different part of Culinaire. It was not. Mr. Lenore's testimony is that he had the same chef and the same food and beverage manager who did this. The difference was a plated dinner versus a buffet. And it's quite a difference. And that's in Mr. Lenore's volume 2, page 222, line 17 through page 223, line 5. At slide 33, we document the increased revenue. You see the revenue increasing from 2017, $932,000, 2018, $2.6 million, 2019, it jumps to $4 million if you include Hamilton, and it's at about $2.8 million without Hamilton. but the average per cap, the average spend per customer, and we must remember that some of these performances are targeted towards children and youth, increased $2.50 over this period to, and $9.96 or $10.02, just rounded to $10. It went up basically $2.50 during that time period. So Culinaire increased the per capita revenue at the music hall's facilities for 3 years in a row. This is Exhibit 141, Mr. Lenore's deposition at Volume 2, page 242, lines 4 through 8. Mr. Schulte's deposition, page 261, line 24 through 262, line 1. Mr. Rule's deposition at page 114, line 20 through page 115, line 4. And this also makes the point, Your Honor, what I was talking about earlier, is you don't know exactly what the damages are going to be until you're able to take a look back. And this gets into how difficult it is to calculate the damages in this case, which is yet another reason why there is no adequate remedy at law here, is because can you get an expert in, an economist, and spend a bunch of money to say, well, I did this theory and that theory? Of course. But then you're going to get argument from the other side that it's subject to Robinson Havner challenges because he's talking about lost profits and so forth. We've got 8 years left on that agreement, Your Honor. The only way to know what those damages are is for the 8 years to run and see what happens and take a look back. That clearly is an inadequate remedy at law because we don't know when the music hall is going to start back up. We don't know what the food and beverage service will look like at the music hall. We believe there will be some food and beverage service, but we're in a pandemic. So it's very difficult to say at this time what it will look like on a go-forward basis. Again, this captures more of why there is no adequate remedy at law, which you mentioned earlier, Your Honor. You wanted to hear some argument on. It's slide 34, their lead-in argument in notice and termination was corrupt business practices. And that falls under, Your Honor, you've got to be kidding me. The so-called corrupt business practice was where the Culinaire, not the music hall, not MGI, Culinaire took Terlato Federalist wine, which traveled with the Hamilton show and was a huge hit. And the food and beverage manager said, sure, can you help me out and get me a night at your winery in Italy, which Culinaire encourages its employees to do when they go on their travels, go visit the winery so you can learn, so you can talk about it, so you can address it with your patrons and learn about it. And they call this a quid pro quo. Of course, they didn't call it a quid pro quo at the time it happened. They had full notice of it in April of 2019. The words quid pro quo only arose at the end of 2019 following a certain impeachment proceeding when that became a hot buzzword. So they wanted Mr. Schulte removed and they said it was corrupt. We violently disagreed with that. There was nothing whatsoever corrupt about it. That wine was needed. That wine was sold. That wine provided funds to MGI and the music hall. In terms of the commission, it was the best-selling bar there because it was popular. It was unique. It went with the Hamilton performance. It was created for the Hamilton performance. So there, in no respect, is there any sort of corrupt business practice. This is Mr. Lenore removed Mr. Schulte when this letter was sent within the time period under the contract. That's at his deposition, volume 2, page 227, lines 5 through 13. There was no quid pro quo. That's at Mr. Lenore's deposition, volume 2, page 212, lines 14 through 21, page 224, line 24 through 225, line 2. Mr. Schulte's deposition at page 242, lines 4 through 13. And he never gave special treatment to anyone to his personal benefit. Occasionally he would he would bring an appetizer to the chairman of the board of DSM, which you would hope he would do. And when folks at DSM would call down and ask, can you get a table for Lyda Hunt or another big donor, he would accommodate that because that's how nonprofits work. These are volunteers that are officers. You try to take care of them and show your appreciation. And obviously you do the same for your donors. And that's at Mr. Nava's deposition, 169, lines 3 through 11, and Mr. Yoshitomi's deposition, line 134, page 134, line 25 through page 135, line 5. There was massive amounts of staff training, Your Honor. Still, they complained there was uncompleted and insufficient staff training. Excuse me. There was Mr. Lenore testified to all the training at volume 2 of his deposition, page 228, line 8 through page 230, line 1. Mr. Schulte testified to the training at his deposition, page 251, line 14 through page 260, line 2. Furthermore, exhibits 132, 133, 134, 135, 136, 137, 138, 139, 142, 143, 144, and 145 are training materials that the sworn testimony from Mr. Schulte and Mr. Rule were used in the training of the staff at the music hall. Did staff make mistakes? Of course. Did staff do things that were stupid and shouldn't have done? Of course. When you're dealing with people, is that going to happen? We all know that. That's the case. But there was training. They even provided new training in March of 2020 when Mr. Rule arrived. And that's at his deposition, page 83, lines 1 through 21, page 84, line 24, and page 51, lines 11 through 19. They complain about documentation. There was a price increase discrepancy. We didn't catch it. When we caught it, we fixed it. We're not perfect. We made errors. Tell us what you want fixing, and we fixed it. And Mr. Schulte testified to that at his deposition, page 244, lines 18 through 22. The menus were provided to Mr. Yoshitomi 1 month in advance as the contract required. Mr. Lenore's testimony is on that point at volume 2, page 232, line 18 through page 233, line 2, and at exhibit 321. There was no haphazard execution. We know that clearly from the objective criteria, Your Honor. The reviews, the financial performance, the compliments on the donor dinners. We worked diligently to address Mr. Yoshitomi's concerns, of course, which is what we should be because we're a good company and we are a good partner. Some of his concerns were quite extreme and nitpicky, but we did our best. And that's at Mr. Lenore's deposition at volume 2, lines 214, page 214, line 20 through line 23. Ms. Shane's deposition at page 69, lines 6 through 10. Mr. Yoshitomi's deposition at page 30, line 17. And then, of course, the ratings at exhibit 152, 322, 325, 117, 331, 332, 333, and 334. And the financial performance is further proof, as I mentioned. The food quality, again, the rating objective criteria, the food quality, exhibit 151 and 331. The reviews during November and December 2019, 4.72 and 4.63. Super high, incredibly high reviews. Why is that? Why are we focused on those? Because remember, they provided notice in November of 2019. So during and after the notice period, the reviews were actually above what is the average. The average is a 4.5 over 1,400, and these are 1/10 to 2/10 higher. And the proof of that is exhibit 320, 322, 325, 117, 331, 332, 333, and 334. Mr. Munsell had at least 23 times that he had dined at the buffet at the Crystal Terrace. When he learned of the termination, he reached out to Mr. Schulte and sent him an email. Direct quote here, Your Honor, from exhibit 129. Personally, I thought you and Culinaire both did well for us. He was the chairman of the board of the Dallas Summer Musicals in 2017 when this extension was executed. Clearly, if there was material mismanagement based on his involvement, he's still on the board today, and there's material mismanagement, he would know about it. There was also issues with the elevator, years of issues with the elevator. So all of our food quality experiences, in spite of the issues with the elevator, which the contract requires them to maintain the elevator, was not done. Mr. Lenore's deposition at volume 2, page 159, line 15 through page 160, line 6, page 160, line 19 through 161, line 19, 161, lines 23 through 24, and page 192, line 8 through page 193, line 20. We talked about, yes, Your Honor.
Mr. Govett, You've used almost all of the 45 minutes. I don't need, because you've provided me a copy of this PowerPoint. I don't need you to tell me what all the citations are with every point that you're making.
Okay.
I've got them right here.
Okay, can we file this with a record? It's in our briefing. It's in our briefing.
And I've got it here. So
okay, it's in our
you don't
briefing.
have to tell me all the sites for every point.
Okay, I'll move along. I appreciate that, Your Honor. I was just trying to make the record because but I'll move along. Slide 39, they haven't paid. Ms. Shane testified. They're not compliant. She also agreed that was a breach of fiduciary duty with respect to their management. If we look at imminent harm, clearly it's imminent, Your Honor. That's the Perales v. Riviera case that we cite at slide 40. Slide 41, we've got the notice letter, the memorandum of understanding, and the termination letter. This is the key because this memorandum of understanding was entered into on February 26, 2020. The notice letter was on November 2019. The termination letter was in April of 2020. And that's slide 42. This is where they memorialize the intent and agreement basically to replace us. And they say they're going to enter into that no later than March 31, 2020. And then after the termination letter was sent, this Exhibit 338, that's what Dallas Summer Musicals sent to the people inside of Dallas Summer Musicals. Spectrum Catering has agreed to come on board. We look forward to working with them. It's slide 44, Your Honor. This is during the pendency of the litigation. They reiterate and reaffirm the desire to work together at Exhibit 339. The irreparable harm, I'm on slide 45. Are you with me, Your Honor?
Yes, I am.
Okay. Threat of loss of reputation supports a finding of irreparable harm. Clearly, there's no material mismanagement here, but they want to terminate us claiming material mismanagement. We got a call from a vendor like a day or two after they sent the letter saying, hey, I heard y'all were out. The word is out. We can file a lawsuit to clear our name, and otherwise we'd be without recourse. And so that argument that they make that we can't seek reinstatement is without merit, with all due respect, Your Honor. There is a threat of loss of reputation here. We have a superb reputation in the industry and in this community. And that's the frequent flyer case that we cite. And our business is significantly disrupted. In fact, it's disrupted to the point where they terminated us. They sent a termination letter, so we don't have a business there anymore. Slide 46, the disruption of the business is losing our exclusive provider status over there. We did very well. We provided very good service over there. We want it back. There was no basis to terminate us. Loss of reputation, this is what I spoke about earlier. Before the vendor learned about the termination before we had, because Spectrum had called the vendor up to arrange accounts. It was the vendor was Glazier's, Southern Glazier's, the alcohol distributor, and the Spectrum called them and said, hey, we're going to take over this account before we even knew about it. And they called us and said, what's up with this? And if you look at 336, that's where MGI authorizes them, go out and do what you need to take over this account. Slide 47, there's no adequate remedy at law if the damages are incapable of calculation or if the defendant's incapable of responding. They have no revenues at current. They have no financial wherewithal. They filed an affidavit, a sworn affidavit with this court, Your Honor, that they said they didn't have the money to hire an additional IT person to respond to our proposed discovery request. That's Exhibit 329. Mr. Navas in his deposition said nowhere does MGI have anywhere close to $4 million. And the $4 million number, Your Honor, is basically what did we make per year, and then we ran it out, present valued it. So again, is it going to fluctuate? Of course it's going to fluctuate. But if they fire back up in April 2020 and things go as planned, it'll be somewhere close to that. Mr. Watson said they only have between $100,000 and $200,000 cash on hand. And in fact, he verified their current cash position was less than $24,000. His testimony at page 49, the cash flow is zero. That's not a secret. We know that. There's no musicals going on. Here's the other key, Your Honor, is to a district court exercising discretion over injunction over an injunction decision, unwillingness to pay is just as significant and perhaps more so as inability to pay. And this is out of Dallas Court of Appeals 2019. They owe the unamortized amount. They owed it 15 days after they terminated. They have not paid it. Nothing. That is clearly unwillingness to pay, which justifies our request for an injunction. This slide, Your Honor, this last slide here, this is why the damages cannot be measured by any certain pecuniary standard. And it is, that's from the Texas Industrial Gas v. Phoenix Metallurgical case, cannot be adequately measured by any certain pecuniary standard. That's where the language comes from. When do the damages begin to run? When they open back up? When will that be? We don't know. What is the volume of sales going to be? We don't know. It depends on the shows. It depends on the quality of the shows, how long they run, what times when equals who knows. Does that mean we can't get an expert to come in? No, I'm not suggesting that at all. But it is very difficult, and it's going to take a ton of time and a ton of money for some expert, if he even can do that. And then, of course, we know they're going to say, well, it doesn't meet Robinson, it doesn't meet Daubert, lost profits. So if we look at the last slide, Your Honor, all we need to do is show probable right to relief, imminent irreparable harm, no adequate remedy at law. We have met our burden. With all due respect, Your Honor, we believe we are entitled to the preliminary injunction and the temporary injunction order that we submitted earlier. And are there any questions?
Two. Actually, one is a comment. The PowerPoint that you sent the court doesn't have your page 51. Instead, what I was given was 51 is now 52, just for what
it
it's
doesn't
worth.
have mine either. It's not mine either, Your Honor. We will send it to you.
Second, I do have a question. I understand the memorandum of agreement between MGI and Spectrum was dated in February of 2020. I think it was the 28th, if I'm not mistaken. Is there 26th? Was there anything in plaintiff's evidence as to when MGI and Spectrum began negotiations that led to an MOU?
Your Honor, what we have, yes, that's in Mr. Yoshitomi's deposition. He went down to Spectrum he went down to visit them at the Hobby Center in Houston in January of 2020. Mr. Yoshitomi lives in Los Angeles. He visited Spectrum at an event in Los Angeles on Valentine's Day of 2020. And that again goes back to, and he also testified, I believe, it's in the deposition. I could pull it out if you wish. But basically the wheels were in motion, we believe, after the December 18, 2019 meeting that certain members of the board had. And then Mr. Thompson, if you recall from our briefing, sat down and met with Mr. Yoshitomi the very next day and said, and Mr. Yoshitomi said, well, I look forward to working with you. And then when Mr. Rule showed up, he said the same thing. I look forward to working with you. And this is the Ving case, I believe, that we've cited, Your Honor, where it's the, yes, Ving Card v. Merrimack Hospitality Systems, Inc. That's 59 Southwest 3rd, 847 at 201. And that case is out of the Fort Worth Court of Appeals, 2001. When you lead somebody on and you engage in this sort of conduct that they did, then you've cured, and you haven't done what you should have done because there was a 30-day cure period there.
All right, you've gone beyond what I was asking, and
I hope, did I answer your question?
You did. Thank you.
Thank you.
Mr. Whitty.
Yes, Your Honor.
Well, just a question before you begin. Would you like 5 minutes? Or do you want?
Yes, Your Honor.
All right. Then we'll take 5 minutes, back at 4:16.
Thank you, Your Honor.
Thank you.
Good. All right, back in here. Please reread my message before the link.
Might as well go back on the record. Mr. Whitty, just for what it's worth, I asked the clerk during the break. They still have not received your hand delivery, which I understood was your PowerPoint.
Your Honor, we're prepared to proceed. We can share the screen with respect to some of this. Prior to me starting my argument, there were two procedural matters I wanted to raise. First was the question with respect to admitting the additional portion of Ms. Shane's deposition testimony.
Absolutely. I mean, let's consider it. Problem is, I don't have a physical Do I have a physical copy of it?
The court showed it, it was filed yesterday with the court. Again, it was also in the hand delivery that we've provided. It's my understanding it's also been emailed to the court reporter.
Okay. Here's what I've, all right, Ms. Rouse, do you have it?
I'm not sure. I've got so much stuff that's been sent to me. I just kind of put it in a folder. What email address would it have come from?
It would have come from, Anna, is it A. Olin or Anna? A. Olin at clarkhill.com.
Okay, I got the exhibit 274, but that's all I've got. I don't have any other emails from Olin that I can find.
Okay.
They can resend it, that'd be great.
Yeah, we'll resend it right now.
All right, and as to 274,
Your Honor, at
I
this
have it
point,
before me. Oh, I have 274 before me. Was it admitted previously? I don't believe so.
no, Your Honor, it was not.
Any objection to the admission of 274?
None based on the representation. It's a deposition exhibit, Your Honor. No objection.
274 is admitted.
The second procedural matter, Your Honor, would be with respect to the unsworn declaration of Vicky Martinez, which was prepared in full compliance with the Texas Civil Practice and Remedies Code. We would simply ask if the court would accept that unsworn declaration and the statement of financial position attached to it, or whether we would need to present Ms. Martinez's live testimony.
My only hesitation in that is I don't have it in front of me. I see that it was e-filed. But unfortunately, it hasn't come through in an image yet.
Okay. If it would please the court.
I will tell the parties, I don't see any prejudice here. And given the way everything else was done, I'm inclined to say to admit it. If it's an unsworn declaration that is submitted under perjury pursuant to the Civil Practice and Remedies Code, that's been the go-to for an awful lot of people since COVID hit, because they don't have access to their notaries, and it's perfectly permitted by the Civil Practice and Remedies Code. So I'm inclined to admit it, but I don't want to say I'm admitting it and without it in front of me. So,
Your Honor, I'm told that it has also been resent to the court reporter,
All right.
Ms. Krause.
You want to
All
give me a second, Judge, and I can send it to you?
yeah, absolutely. And let's talk calendar anyways, gentlemen. I'm not going to issue a ruling today. I'm going to look at some of this stuff. I'm going to propose one of two things. My calendar tomorrow morning has opened way up. My calendar tomorrow afternoon, late, has opened way up. We could come back together sometime tomorrow for a short period of time, or Thursday afternoon for a short period of time. Thursday afternoon might actually work better at 2:30-ish. But would anyone be offended if a ruling didn't come out until Thursday afternoon? Would that cause anybody any problem?
No.
Put it that way.
No, Your Honor.
No, Your Honor, my only issue is I'm in tomorrow and Thursday, I have depositions, and here's the complication. The case is in federal court in Los Angeles. The lawyers are in Washington, DC, and here in LA, so it's just a difficult situation. I could do something in the morning, depending on how long the court wanted to do, but my deposition starts at 11. Both mornings.
11 tomorrow
Friday
or 11
is no problem.
Thursday?
I'm sorry?
11 tomorrow or 11
Both days.
Thursday?
Both days. It starts at 11 both days. The witness is, tomorrow is the plaintiff in the case, and Thursday is the witness, is the defense time in the case to examine the witness.
Got a summary judgment on Thursday in which they have filed in violation of all the local rules in excess of 1,200 pages of of attachments to their motion for summary judgment. So I probably don't have Thursday morning.
Is there any time Friday, Your Honor?
That's what I'm looking at right now. Yes, Friday at 2:30 or 3. Would that work for either of you or both
Yes.
of you?
Yes, Your Honor. I'll make it work.
Then let's shoot for
Yes.
2:30. We have we have an existing afternoon docket with Zoom ID, so we can Ms. Rouse can send you the links to that, and we'll just proceed after my 2 o'clock motion for protection. So
Thank you, Your Honor.
should be over by 2:30. Okay. And we can clear up any lingering issues on the record at that point too. Ms. Rouse has just sent me the appendix. It includes, I've got them both. Might as well do this right now.
Could you send me an Outlook Friday at 2:30? I'll remember, but.
Okay, I have before me what was listed as an exhibit A. I get exhibit L, which I guess is an exhibit L to MGI's binder. It includes, and I'm going to pull out of it, pages 1, 2, 3, 4, 13, 34, 35, 36, 37, 38, 39, 40, 41 of Ms. Shane's deposition. If I understand what we were doing previously, I'm going to mark that as Court's Exhibit 12, and we're going to consider it part of the testimonial evidence presented in this hearing. Is that agreeable to the two of you?
Yes, Your Honor.
Yes, Your Honor.
It is done. And then I have an unsworn declaration of Vicky Lynn Martinez. It consists of 2 pages plus 2 pages that are listed or identified as financial statements for the 9 months ending July 31, 2020, internal only, unaudited. What shall I mark that as? What exhibit number?
Your Honor, we could mark that as either a court's exhibit in succession of the deposition testimony, or to make sure we avoid any duplication, we could mark it as Exhibit 600.
That was 600 is exactly what I was contemplating, actually, so that there are no duplicates. All right. I'm putting an exhibit sticker on those 4 pages as Exhibit 600. Are you offering 600?
Yes, Your Honor, we would offer 600 and ask that it be incorporated into the record.
Mr. Govett, I have heard your objections to 600 previously. Is there anything you want to add to that?
No, Your Honor, nothing further.
All right, 600 is admitted.
I do have one question, Your Honor. We're continuing the hearing. So at this juncture, is the evidence frozen, so to speak? Here's why I ask. Because the declaration came in late last night. I can go out and get declarations. I don't think that's what the court is wanting or inviting, but I'm just asking.
But I'll just say it's continuing. We'll continue this hearing, and I'm hoping all I'm doing is issuing a ruling. But if I've got questions for counsel, I may ask them. If you've got something else to add, we might as well make sure the record is absolutely clear. If there's something of real clarity, don't change the nature of the ball game on Friday. But I'm not inclined to say the evidence is closed today. So I'm hearing your closing arguments. So if you got anything to add, this isn't the normal way we do things anyways, because of COVID. So we're gonna work to make it work as best we can.
Understood. I appreciate that, Your Honor. Thank you.
You're welcome. Mr. Whitty, are you ready to proceed?
Yes, Your Honor. And if we may do a screen share, please.
You may.
Thank you, Your Honor, and may it please the court. As the court's aware, this is a contract case. Culinaire claims that DSM Management Group wrongfully terminated the food and beverage management agreement between MGI and Culinaire. Culinaire seeks, in this case, obviously an injunction, but it also seeks and has asserted in its brief that it has stated damages. Mr. Govett also argued earlier that if we get an expert, we will be able to calculate damages. As the court is aware, the Supreme Court of Texas has stated that generally a court will not enforce contractual rights by injunction because a party can rarely establish an irreparable injury and an inadequate legal remedy when damages for breach of contract are available. And that's in the Budnaler versus Ford Motor Company case. Chevron USA versus Stoker took it further, saying extraordinary circumstances are generally required to enforce contract rights via an injunction. Your Honor, this is not the type of situation where you cannot establish damages for breach of contract. This is not an extraordinary circumstance that the courts require to grant an injunction to enforce contract rights. Now, as has been noted, we look at a probable right to relief. We look at irreparable and imminent harm. We look at the adequate remedy of law. With respect to the probable right of relief, we acknowledge the lower bar that Culinaire must cross. However, Your Honor, they have not gotten to that point. In fact, Jay Schulte, who up until November of 2019 was Culinaire's general manager at the music hall, gave his deposition in this case. After reviewing a number of reviews that had been captured using Culinaire's own Resi system, Mr. Schulte answered this line of questions. Does this reflect an acceptable food and beverage experience by music hall patrons? No. Should MGI and DSM expect better in the food and beverage services at the music hall? Yes, sir. If MGI and DSM, their patrons, do not receive a better food and beverage experience than is reflected here, should they be able to find someone who can provide a better food and beverage experience? I suppose so. Do these patron comments, in your opinion, reflect proper management of the food and beverage services at the music hall? And he responds, no, sir. So the individual who at the time was Culinaire's general manager at the music hall, in testifying about reviews that were captured by Culinaire's system in the August 2019 timeframe, testifies that these patron comments do not reflect proper management of the food and beverage services at the music hall. Now, Mr. Schulte's successor, John Rule, also addressed those reviews and agreed with respect to the kitchen management. We ask, are these comments reflective of proper management of the food and beverage services at the music hall? And he says they had serious issues with the food quality. I would say the kitchen management. So in this context, Your Honor, with respect to this issue, Culinaire's former general manager and the general manager that was in place at the time of termination had both agreed that there were significant management issues with respect to Culinaire's food and beverage services at the music hall. Now, with respect to the point of imminent harm, Your Honor, Jane Shane is the chair of the board of Dallas Summer Musicals, related entity to DSM Management Group. The city of Dallas owns the music hall. The city of Dallas leases the music hall to the DSM Management Group on a long-term lease. The current lease runs through 2029, and there are extensions that enable the lease to continue to 2049. Jane Shane is the board chair of Dallas Summer Musicals. Now, she testified with respect to the current status of the music hall at Fair Park and the musicals. Unfortunately, in the midst of this pandemic, as Shane testified, that we do not expect to have musical theater back in the music hall until hopefully April of 2021. As such, Your Honor, there are no food and beverage services being provided at the music hall, likely until that time. There is no immediate harm. There is no imminent harm. In this situation, even if DSM carries forth as the testimony sets out, DSM would first engage in an RFP process to encourage potential applicants to submit proposals to submit the food and beverage services at the music hall. At this point, that process hasn't even started. So an injunction that would preclude DSM from contracting with another party, that potential harm that even Culinaire alleges is months off. There is no immediate and irreparable harm here. Mr. Lenore, who is Culinaire's regional manager, even testified on this point. Mr. Lenore was asked, given the current pandemic, there are no food and beverages going on right now at the music hall. Is that correct? He answers, that's correct. And the question, and so at this point, Culinaire is not incurring any losses of revenue from a food and beverage standpoint based upon this termination with respect to the music hall. Is that correct? Mr. Lenore says, that is correct. Culinaire is not suffering any injury at this time. Culinaire does not stand to suffer injury at any time immediately, imminently, or in the near future. Now, beyond that, Your Honor, we have talked about an adequate remedy of law. And I think Culinaire confuses cash in the bank or the ability to pay for something now as opposed to sufficient assets to satisfy a judgment. It is true that Ken Novice testified in the context of discussing whether or not MGI would have had sufficient funds to pay for additional staffing as well as the additional manpower in the context of Culinaire's request that MGI be forced to produce documents within a 7 to 10 day time period following the request. So Culinaire's motion for expedited discovery sought production within 7 to 10 days. Now, with respect to that, MGI, in working with its firm, was provided information from our firm's IT staff on the amount of money that it would take to review well more than 500,000 documents, including more than 151,000 documents that satisfied certain search terms, and to have those documents reviewed and produced in a 7 to 10 day time span. As the court might imagine, that number exceeded $200,000. Mr. Novice also addressed the issue of MGI having to go out and hire additional staff. Now, with respect to that, you're dealing with an issue of cash flow. And so Mr. Novice's testimony, which was true, was that at the time, MGI did not have sufficient funds immediately available to enable it to spend those extraordinary amounts of money that would have been required had MGI been required to produce documents within a 7 to 10 day time period. Now, ultimately, in conjunction with the hearing with the court, the parties agreed for that production to take place in 28 days. And so in this context, Your Honor, we agree that the DSM management group does not currently have sitting in a bank account an amount that Culinaire claims is its stated damages. Now, we'll also note, though, that nowhere in this record, as broad as it is there any evidence that supports anything anywhere close to Culinaire's, quote, stated damages of $5 million. So even in that context, where again, in its briefing to the court, Culinaire states that MGI can't pay a judgment of $5 million. Culinaire specifically asserts its stated damages of $5 million. This record does not support that. In fact, this record at this point doesn't support any damages. Now, with respect to that though, Tom Watson, who's MGI's board chair, specifically testified with respect to MGI's assets. And the question, so at the end of the fiscal year, that's the end of the fiscal year 2019, when you talk about cash and accounts receivable, did MGI have in excess of $3.3 million? The answer, yes. Now, the overwhelming majority of that was in accounts receivable. Mr. Watson then testifies, and with respect to property and equipment, did MGI have an additional approximately $1.6 million? The answer again, yes. With respect to MGI's current cash position, as of February 27th, I think that's the last day you were able to verify, was the cash in the bank less than $24,000? He says yes. Follow-up question, however, were the total assets of MGI, non-cash assets, still in excess of $4.5 million? The answer, yes. So just because MGI did not have a large amount of cash in the bank, MGI at that point still had very significant assets. Now, in the unsworn declaration of Vicky Martinez, which the court has addressed earlier, Ms. Martinez is the Vice President of Finance of the DSM Management Group. She sets forth the predicate with respect to the financial statement attached. The financial statement is for the time period ended July 31st of 2020. That financial statement reflects $4,013,551. With respect to cash and cash equivalents, restricted cash, accounts receivable, and property and equipment. Thus, Your Honor, we would assert that very clearly the DSM Management Group has sufficient assets from which, in the unlikely event that Culinaire recovers a money judgment in this case, Culinaire could exercise and execute upon those assets in absolute fulfillment of any such judgment. Now, Your Honor, with respect to the contract itself, there's been reference to it already, and in the interest of time, we will not belabor. But it is key to focus on Agreement Section 7.1, which addresses product and service quality and the required service standard. It makes clear that Culinaire will provide sufficiently trained management and personnel. As the court is aware from our briefing, we believe that Culinaire has fallen well short on that measure. It requires that Culinaire expend a reasonable effort to maximize revenues, where the testimony is Culinaire has done almost nothing to bring in outside third-party events to the music hall. It requires that all food services shall be of the highest quality in the context of this region. Now, to be very clear, no one, not Culinaire or not MGI, has taken a position that just because you're in this region justifies a lower quality. The provision requires that Culinaire shall conform to all applicable laws, ordinances, and regulations. Again, we've shown, and we'll discuss further here in a moment, how that has not occurred. It requires that Culinaire shall implement and enforce appropriate rules and regulations to ensure that its employees conform to this required service standard. Not only will we show, Your Honor, that Culinaire failed to provide such training and guidance on the front end, we have shown the court numerous instances in this record where its employees have failed to follow such rules and regulations. We've also shown that in those instances, Culinaire was reluctant, if not refusing, to issue written reprimands to its employees. And we'll also show that Culinaire, even after those instances, refused to go train its employees about the importance and steps required to conform to the required service standard and the rules of regulations that were a part of it. Now, Culinaire acknowledges at the end of that provision that the provision of food service in accordance with the required service standard is a material term to the agreement. Now, with respect to provision 7.3, it addresses the safety standards, states that Culinaire shall be required to comply with all rules, regulations, and safety standards. Culinaire shall at all times enforce by adequate supervision and training. Culinaire, according to Jay Schulte, its former general manager, hired a company called EcoSure to come in and do independent inspections of its compliance with health and safety standards. Mr. Schulte says that Culinaire did so that they could, in essence, beat a health inspection, so that it would prepare them for a health and safety inspection on a governmental level. Now, on 4 occasions between 2017 and 2019, including 2 occasions in 2019, Culinaire had EcoSure perform a health and safety inspection at the music hall. On 3 of those 4 occasions, Culinaire did not obtain an acceptable score by its own standards on those inspections. And unfortunately, 2 of the lowest scores, both unacceptable, were in 2019. Now, Your Honor, with respect to agreement provision 8.2, it specifically says that all employees shall enter and leave the venue via the entrances designated by the manager being that individual with the DSM management group. As the record shows, there were numerous instances where Culinaire's employees improperly entered and exited the building. Further, in that provision 8.2, at no time will Culinaire permit the free entrance of any person not an employee for such event or events. This is basically addressing the specific instance where Culinaire would have employees bringing in non-employees through a back elevator for the purposes of trespassing onto the property and viewing a performance without a ticket. You know, for example, with respect to the performance of The Illusionists, Culinaire employees were caught bringing non-employee family members back through the service elevator into the music hall so that they could, if they weren't caught, view the performance of The Illusionists without purchasing a ticket. Now, these individuals were caught. And in fact, this instance was reported to Mr. Schulte. Mr. Schulte did not even go so far as to issue a written reprimand. Mr. Schulte also testified that he believed that the employee involved was an individual named Stormy, who remained employed by Culinaire well after that instance. So agreement 8.2 specifically says, and it shouldn't even have to, Your Honor, but it says in essence, you will not enable non-employees to trespass on this property. Yet Culinaire did not adhere to that provision. And when it became apparent that it didn't, there was no action taken. Similarly, there were a number of instances where culinary employees abused parking passes that they received as part of the State Fair of Texas. Culinaire, for example, provides the food and beverage services at an event on game day itself. And so Culinaire employees have to have parking passes that they use to enter that area. But those parking passes are designed only to be used when those employees are working. On numerous instances, MGI and DSM employees notified Mr. Schulte because they had been notified by the State Fair of Texas that culinary employees were abusing their parking passes, in essence trespassing when they were not working. Thus, a provision that would seem to be very clear-cut and not in debate comes to issue with Culinaire sneaking employees' families in through the back elevator, Culinaire's own employees abusing parking passes. Now, provision 8.4, Your Honor, addresses special events. And as I've made the point earlier, it requires Culinaire and MGI to promote, solicit, and schedule special events at the venues. MGI has staff in place for this. Culinaire does not. Jay Schulte testified that at the time he was discussing a broader issue of marketing with Paulette Hopkins, that in essence, Culinaire had one person as their marketing department, and that person was horrible. Now, it's even been testified to by Mr. Lenore that Culinaire did not deem it worthwhile to retain staff to meet its requirement to promote, solicit, and schedule special events at the venue. Now, with respect to agreement provision 9.9, says that Culinaire shall engage and pay for exterminators to control vermin and pests in the food service areas as is necessary or required by law. Now, Culinaire acknowledges that they have been the food and beverage provider at the Music Hall at Fair Park since 2008. Even with this provision, Culinaire acknowledges that prior to 2019, it had not engaged and paid for exterminators to control vermin and pests at the music hall. In fact, it was only after Culinaire received one of its unacceptable EcoSure reports showing that it had failed to meet Culinaire's required standards for health and safety at the music hall, did Mr. Lenore reach out to Mr. Schulte to say, apparently, our contract requires us to engage and pay for pest control. So Culinaire yet again acknowledges that it has absolutely failed to meet this provision of the agreement. And in fact, Mr. Lenore has testified that even after he became aware of that, Culinaire has not since then retained a pest control company or an exterminator to service the food service areas at the music hall. Now, agreement 9.14 addresses signage and advertising. It says that all advertising and signage placed in the food service areas by Culinaire shall be submitted to the manager, that's MGI's designated individual, for prior written approval. Now, there are numerous communications addressing this issue. And in fact, MGI raised the issue specifically in its November 22nd, 2019 formal notice correspondence to Culinaire. Even after that communication, Culinaire took no action to obtain the necessary approval of the unapproved signage that even as of the date of termination, Culinaire continued to use at the music hall. Now, Agreement 12.5 specifically states, with respect to objections to employees and management, that upon written notice of any objection, Culinaire shall promptly remove objectionable employees no later than 1 day after such notice. Now, Culinaire was keenly aware back in April of 2019 that MGI objected strongly to Jay Schulte, its general manager, continuing in place at the music hall. Understandably, MGI was willing to allow Culinaire to, at Culinaire's request, keep Mr. Schulte in place until the end of the 2018-2019 season, which ended in August of 2019. Culinaire had asserted that making the change immediately would disrupt operations and harm its ability to provide food and beverage services at the music hall. So after that request, Culinaire promised, Mr. Lenore promised that Culinaire would have a new general manager in place no later than the beginning of November 2019. That did not happen, and we'll address that further here in a moment. However, in this instance, it required MGI to formally, in its November 22nd correspondence, demand that Mr. Schulte been removed. Now, with respect to provision 12.7, courtesy, Culinaire shall train and closely supervise all employees so that they're aware of and habitually practice the highest standards of cleanliness, courtesy, and service. We will show that yet again, Culinaire fell well short on this standard. Safety, 12.9. Culinaire shall train and refresh all employees on an ongoing basis on appropriate areas of food safety, proper food handling, and life safety. Yet again, the record and our briefing has set forth numerous instances where Culinaire failed to properly train its employees on these issues, where Culinaire failed to provide refreshing training to these employees, and where Culinaire's own internal company, EcoSure, time and time again, set forth that Culinaire fell short of that. Now, Agreement 12.2 addresses parking for employees. These parking areas for employees shall be designated by the manager. Culinaire shall not park any vehicle at the receiving dock except for immediate loading and unloading. Again, as noted in our briefing, on numerous instances, Culinaire failed to honor this provision. And so, Your Honor, the crux of the termination is Agreement Provision 16.2, which says that the agreement shall terminate immediately upon the delivery by MGI of a written termination notice to Culinaire, which is issued after the occurrence of any of the following events. And subpart D, if in the reasonable judgment of MGI, the Crystal Terrace restaurant, the bistro, and or the concession services operations. So again, this requires one of three. If either the restaurant or the bistro or the concession services operations under the agreement are materially mismanaged by Culinaire, whether due to a lack of appropriate supervision by responsible officials of Culinaire or otherwise, and the continuation of such material mismanagement for a period of 30 days after such written notice thereof from MGI to Culinaire, specifying the nature of such material mismanagement has not, in the reasonable judgment of MGI, been corrected. So, Your Honor, as the court knows, this is not Culinaire's reasonable judgment. It specifically states if in the reasonable judgment of MGI. And so you look at the issues that we've already talked about and that we'll get in more detail with respect to Culinaire's performance and Culinaire's numerous areas of material mismanagement of, in fact, all three of the components, the restaurant, the bistro, as well as the concession services operations. Now, we've mentioned Mr. Schulte. Mr. Schulte, under Culinaire's watch, allowed countless instances of violations of the agreement without so much as a written reprimand. There were numerous instances in Mr. Lenore's deposition, and Mr. Lenore was Mr. Schulte's supervisor, was his boss. There are numerous instances in Mr. Lenore's deposition where he states that he should have been told about these violations of the agreement, these specific instances, but makes clear that he was not. Now, as part of MGI's effort to provide exceptional patron experiences for all guests coming to the music hall, MGI and DSM had a patron services committee that was comprised of its own employees that address patron services, as well as representatives of the outside companies such as Culinaire, which play a role in the patron services experience. This committee met weekly. Mr. Schulte has testified that creating an exceptional and amazing patron experience was a priority for DSM and MGI. Both Mr. Lenore, Mr. Schulte, and Culinaire's president, Mr. Thompson, stated that they knew that the patron services meetings were important, and they knew that it was expected that either Mr. Schulte or someone in his place would attend those meetings. Yet Mr. Schulte regularly missed those meetings. He failed to send anyone from Culinaire in his place. There's email communication with Paulette Hopkins of DSM, in essence saying, Jay, why aren't you attending the meetings? Another email, we are missing you at the meetings. We are addressing issues related to the restaurant, and we would appreciate it if you or someone from Culinaire would be there. So time and time and time again, in this most important setting, addressing the patron services experiences of the patrons coming to the music hall, Culinaire knowingly did not show up for these meetings. And even when they did, in an instance where Mr. Schulte was handed reviews, patron reviews, about Culinaire's food and beverages services at the music hall, Mr. Yoshitomi testifies that Mr. Schulte made a point of throwing those reviews away. Now, Mr. Schulte regularly received patron comments from MGI and DSM. Now, Culinaire also, back before their Resi review system launched in 2019, Culinaire would receive handwritten comment cards from patrons who came and dined at the music hall and who took their time at the end of their meal to write comments addressing their experience at the music hall, at the restaurant. Culinaire's president, Bill Thompson, has testified that on not one occasion did he ever, prior to the Resi review system, review any of those comments. I'll also assert that throughout the time period, there are no emails from Mr. Lenore to Mr. Schulte, from Mr. Schulte to anyone at Culinaire, addressing negative patron comments. Mr. Schulte went so far as to confirm that he made little to no effort to contact patrons about their comments unless he knew them. We've also addressed that Mr. Schulte and Culinaire failed to properly train Culinaire's employees. And even beyond that, we've addressed early on that Mr. Rule, who was Mr. Schulte's successor, stated that he noted areas of kitchen mismanagement in the August 2019 patron comments. Yet even knowing that, Mr. Rule provided no training of the kitchen staff during his admittedly short time as Culinaire's general manager. Time and time and time again, within this record, there are instances where Culinaire absolutely failed to properly train its employees. Now, with respect to Mr. Schulte, Mr. Yoshitomi testified Jay was present at the music hall. He was interacting with the staff, but he wasn't engaged when something would go wrong, or when I would address a problem with him or bring an opportunity to him. He didn't engage in a way that I thought was entrepreneurial or in furtherance of a shared goal to increase service and revenues. He was quite passive. Dead inertia, I think, is a good way to explain it as well. He did what he did and nothing was going to change that. MGI's president, Ken Novice, testified Jay was often dismissive and not particularly helpful, and in some cases didn't seem to listen at all to what I had to say. That kind of dismissive communication or lack of communication, I also heard from other people on staff who had that same interaction, that kind of direction with Jay where he would either ignore or dismiss communication with them. I also saw on some occasions where folks had tried to talk to Jay and he just sort of turned his head and walked away. In addition to that, I would say that the overall food quality of Culinaire never lived up to what we wanted it to be after numerous conversations with Jay. Now, given this, and in the interest of time, we have provided the court with a number of the patron reviews that Culinaire received in the year 2008, as well as reviews that DSM provided to Culinaire in 2008. And so we have that both in Exhibit 560 with regards to Culinaire's comment card reviews. We also have it in Exhibit 232, 234 with respect to those provided by DSM. As the court will note in reviewing—
And you provided,
Pardon me, Your Honor?
oh, I was gonna say, and you provided them in your brief, so I've
Yes.
I've
Yes.
read them.
Yes. And so, Your Honor, given that, in April of 2019, MGI specifically, through Joseph Yoshitomi to William Lenore, made a specific request that Culinaire replace Jay Schulte as the food and beverage manager at the music hall. Now, one instance immediately prior to that took place with respect to Terlato Wines. And that's Exhibit 233, where Ryan Butler of Terlato Wines specifically asks Jay Schulte, will you purchase some additional cases of wine? Mr. Schulte responds, yes, but if I receive a stay in your Italian villa. Now, Culinaire's counsel says there's nothing wrong with that. We want people to go and explore, etc. He basically says, sure, I will purchase additional cases of wine in return for an overnight stay in Italy. I'm going there in October. Now, the record shows that Mr. Schulte followed up on that and in fact did go to the Terlato Wine property in Italy upon purchasing those additional cases and upon receiving that free stay for him and his guests. Now, Mr. Thompson, Culinaire's president, specifically says it is not acceptable for a Culinaire employee to specifically condition the purchase of a beverage product upon receiving a personal benefit. And that is exactly what happened here. In addition, MGI has concerns as well. The music hall is owned by the city of Dallas. DSM and MGI are both nonprofit organizations. As the letter from Terlato Wine shows, they either thought or had been told that Jay Schulte was the owner of the music hall. In this context, Mr. Schulte also says he was willing to take for himself, but never once thought to ask Terlato Wines or any other vineyard to provide benefits, auction items for Dallas Summer Musical's fundraising events such as the gala. And so in this situation, in light of Mr. Thompson's testimony, it's not acceptable. We certainly agree with that. And Mr. Yoshitomi raised it to Mr. Lenore. But Mr. Yoshitomi also raised numerous different concerns that MGI had with respect to the management that Culinaire had at the music hall. Now, in April 2019, after Mr. Schulte asked to remove, Mr. Yoshitomi asked to remove Mr. Schulte, Mr. Lenore testifies, at what point did he first express to you the request that Culinaire remove Jay Schulte? He says April of 2019. Mr. Yoshitomi then followed up on that. And then in Mr. Lenore's deposition on page 21, he testified that Mr. Yoshitomi was told to expect that Jay Schulte would be replaced as the general manager at the music hall prior to the season beginning in November. However, Mr. Lenore also testified that at the time he made that statement to Mr. Yoshitomi, at the time Culinaire promised MGI that the change was coming at the beginning of November, Mr. Lenore knew that the president of Culinaire, Mr. Thompson, had not approved that request.
You've been at this for, you've been at it about 45 minutes. May I suggest you bring this to a close?
Yes, absolutely, Your Honor.
And then I've got a question.
Yes, Your Honor.
And it said, and then I've got a question.
Okay. Your Honor, given all of this, knowing that Mr. Schulte was going to be replaced, MGI took the very wise step of bringing in an outside hospitality consultant firm, Fessel International, to perform a review of Culinaire's operations at the music hall. MGI received that report, which noted numerous management and operational deficiencies. Instead of just receiving the report, MGI took the steps of investing the time and effort into a performance improvement plan that enabled MGI to work with Culinaire, seeking to bring Culinaire up to the standard required under the agreement. There's countless evidence in the record of the meetings, of the efforts, etc. Yet even during that time period, you continue to have instances where you would have hair and food in a donor lounge. You would have instances where Culinaire employees engaged in confrontations with MGI and DSM patrons, including a 12-year-old child. Even worse, Your Honor, when that was reported, Jay Schulte then went to an MGI employee claiming that that person should not have reported the instance of impropriety by Culinaire. In that instance, Mr. Schulte directly confronted Ms. Rollins, an MGI and DSM employee, and confronted her. Her email says it made her feel uncomfortable. Mr. Yoshitomi testified that he's seen her cry twice, once when she lost her husband and once when this instance occurred. She said she felt threatened. She said she felt harassed. Mr. Yoshitomi reported this to Mr. Lenore, and he took absolutely no action. Mr. Lenore testified that that type of behavior would violate Culinaire's in-house policies, yet he did not even feel it was worthy of an investigation, let alone taking action against Mr. Schulte. Your Honor, later in November of 2019, MGI and DSM had to go so far as to encourage and implore Culinaire to tell its employees to stop eating the food that MGI and DSM had paid for its donor lounge. Mr. Lenore even admitted that in essence, eating that food that was being paid for by DSM was theft. And even in that instance, Your Honor, there was no step taken by Culinaire to reprimand those employees, to properly train those employees, or to take any other action. Now, after MGI provided Culinaire with formal notice of the areas of material mismanagement at the music hall, Culinaire continued to follow short and in essence displayed an absolute disregard for those points. Mr. Thompson testified that when he met with Mr. Yoshitomi, he was not prepared to discuss the issues raised in that letter. Mr. Lenore testified that when he was interviewing and when he brought on Mr. Rule as the new general manager, he never discussed either the letter or the issues raised in the letter with Mr. Rule. Mr. Rule confirmed that by saying that when he first met with Mr. Yoshitomi at the music hall, that he was not aware of any of the issues that MGI had been working through with Culinaire. He had not been provided any of the Resi reviews and prior written comments. He was simply absolutely unprepared to step into that role. Now, with respect to balancing the equities, Your Honor, as we've said, the music hall is owned by the city of Dallas. The city has a strong interest in proper management of all functions at the music hall. It has a strong interest in ensuring that the food and beverage operations generate sufficient revenue, because under the lease with the city, a portion of those revenues go towards maintenance expenses. The city of Dallas and MGI have a strong interest in ensuring an outstanding patron experience and ensuring that the laws, ordinances, rules, and regulations have been followed. Most importantly, the city of Dallas and MGI have a strong interest that employees work in an environment free of confrontation and harassment, and that they are properly trained in the rules, regulations, laws, and ordinances that are applicable. Now, Ms. Shane has testified in her deposition about the leadership role that Dallas Summer Musicals and MGI are playing in this current pandemic world. And as part of that, the Performing Arts Center Consortium Advisory Committee on Reopening has issued a report that addresses what this process looks like.
Bring this to a close.
Your Honor.
All that's in the brief, so.
And I'll simply say, Your Honor, that report shows that there are going to be very stringent requirements. And given the record in this case, there is no evidence supporting that Culinaire would take the time, attention, and effort to follow them. And so, Your Honor, we respectfully ask that this court deny Culinaire's application for temporary injunction in all respects. Thank you.
Does the contract require MGI to, within 2 weeks or 10 days, reimburse Cullen/Air for the amortized value of the improvements that were made upon the contract renewal?
Yes, Your Honor, it does.
Has MGI done that?
Your Honor, MGI has not. Litigation ensued prior to, or litigation was threatened prior to the time at which that money would have been due. And those funds are currently sitting, and I'll represent to the court, those funds are currently sitting in our law firm's trust account.
Has Cullen/Air been advised that those funds are sitting in your trust account?
I can't get into settlement discussions, Your Honor. There has been minimal, but one settlement communication made. It was not made with respect to a statement that the funds were in the trust account. But very recently, and in fact, yesterday, I had raised the issue with Mr. Docket.
I wasn't asking about settlement. I mean, that was the contract has been terminated.
Correct.
And you're alleging for cause.
Yes.
And the contract provides that the MGI must reimburse them, and I'm asking if that's been done.
It has not been done because Cullen/Air has definitively taken the position that the termination was improper and has refused to take the steps that Cullen/Air was required to take upon termination, as far as removing its property from the music hall, as well as the additional steps that the agreement requires Cullen/Air to take after termination have not been taken.
Okay.
Your Honor, I'm happy to respond on that if you wish.
I've heard what I need on that.
Okay.
Thank you, Your Honor.
Oh, thank you, Mr. Whitty. If there is anything any case law that provides, and I mean direct, I'm talking Supreme Court of Texas case law or Fifth Court of Appeals here in Dallas, not persuasive authority, besides the Butnaro and the Chevron cases that directly addresses this issue, the issues of immediacy of harm and adequate remedy at law. I'd really like counsel to send the court note. You don't have to brief them or anything. Just tell me what those are. I've got the cases that are outlined in. I mean, to me, those seem like the prime cases. Am I reading? Am I right or wrong on that, counsel?
Well, I think the question also, Your Honor, is the propriety of a temporary injunction to breach a contract case. We have a number of them cited in our briefing. You asked for Supreme Court, Butnaro and RWI construction. The RWI is the Dallas case. The Butnaro is the Supreme Court case.
I've got those sites. Mr. Whitty, is there anything else that tells me what I've got to do?
Your Honor, I think we've cited them in the brief, but we will most certainly go back. The issue of requiring the extraordinary circumstances and the rarity of issuing temporary injunctions in contract matters is something that we will see if there are additional cases above and beyond. We didn't want to necessarily just string cite.
And I don't want string cites. I want to know. I pay attention to what the Supreme Court tells me to do, and what the Fifth Court of Appeals tells me to do. And I don't need strings out of. Well, Houston did this and El Paso said that. I don't need that.
Okay.
When I've got some real clear direction from those from Supreme Court on this, I believe. So.
Correct.
Very good. And we are in recess. We will reconvene Friday morning or Friday afternoon at 2:30.
Thank you, Your Honor.
Quick question, Your Honor. On Friday afternoon at 2:30, we'll have a chance to respond to those arguments. What is the intention of the court what would you like to hear or do at that point in time?
What do you need to do to respond? I mean, realistically, I've got more, and trust me, the stuff you gentlemen covered, the last word isn't going to make the difference.
I understand.
I've got all of this in writing, and I've seen all of it. So
there's one exhibit that I noted that is in a deposition, and we would like to add it to the record while Mr. Whitty was arguing. And then that's about it, really. Just say, you know, look, compare the termination versus comparing the argument. That's it. I mean, I think we did that in our reply. We could have used more pages. That's about it.
if you got something you just are jumping up and down that you got to advise the court, I will give you both that opportunity on Friday afternoon. Briefly.
I'll try to.
I'll be blunt. I'm stuck between the facts and the law here, and they may dictate different outcomes. And I'm
Understand.
So how I would rule on a breach of contract is not necessarily going to be how I'm going to rule on a temporary injunction. And I trust that counsel is understands what I'm saying, and I'm not previewing because I'm going to reread those cases and make sure I've got this right on the law. So
Understood.
all right. Very
Thank
good.
you, Your Honor.
Thank you, Your Honor.
Recess until 2:30 on Friday.
Thank you, Your Honor.
Thank you. Ms. Rouse, Manana, we have I've seen an email come over that 9:15 canceled.
Yes, sir.
I'm giving blood at 8 o'clock tomorrow.
Okay.
I give blood on Wednesdays at 8 o'clock because I can usually make it to the courthouse by 9. Going back when I was an attorney and I knew I could do it. And so odds are I'll be here, but if I'm running 5 or 10 minutes late, it's only because it just took longer. So tell counsel not to worry.
I'll word her away. Okay. All righty.
All right. And very good. I will have the physical record sitting on your desk here in the courtroom that keeps it separate and apart from everything else. So I know we've got everything for a full record.
Okay, awesome. Thank you.
All right. Thank you.
All right, see you in the morning. Thanks.
All right. Now, did you get my inclination there? What I was telling them?
Maybe my brain's tired, but
I think the summer musicals used a pretense to get rid of Colin Air. When they're going down, the employees snuck in. It's like, really? But I'm afraid they're right on the law. I think there's a different outcome. They got a breach of contract case. I don't know. We need to be off YouTube before we're having this discussion.